For those watching the live stream, welcome to the second day and the final day for the spring session of the Supreme Court. We're prepared to call the first case.
The first argument is Dale E. Albert versus Sheeley's Drugstore and Zachary Ross. Representing Mr. Albert is Mr. Michael Schaefer. Representing Sheeley's Drugstore is Mr. Gregory C. Kunkel.
The appellant estate appeals from the Superior Court's order affirming the trial court's grant of summary judgment in favor of appellee Sheeley's Drugstore based upon the drugstore's assertion of the legal doctrine of in pari delicto, which bars recovery by one whose damages are caused by their own illegal conduct. The estate brought a lawsuit seeking wrongful death and survival damages following a death from an overdose after the deceased ingested contents of a fentanyl patch. The patch was prescribed to the decedent's friend's mother. The decedent drove his friend to the defendant's drugstore to pick up the prescription after his friend had the prescription filled by falsely pretending to be his mother. Following the decedent's death, his estate filed a lawsuit alleging that the drugstore was negligent in allowing the friend to obtain the mother's prescription for fentanyl, which is a controlled substance. The drugstore filed a motion for summary judgment. Trial court granted that motion on the basis of in pari delicto, concluding that recovery was barred by decedent's harm because decedent's harm resulted from his illegal conduct. The Superior Court affirmed on appeal, and we granted allowance appeal to determine as a matter of first impression whether the doctrine of in pari delicto applies in this type of scenario. Mr. Schaefer, feel free to proceed. You get 2 minutes uninterrupted, and then we'll start asking questions.
Thank you, Justice. Michael Schaefer from Schaefer and Geyer for L.M. Thank you very much for time today. The question for the court today, confronting the court, is whether the Superior Court's expansion of the in pari delicto will be allowed to stand. Because if it is allowed, every defendant will then use that doctrine to then substitute what has been used for comparative negligence or assumption of the risk, and use those. It's going to substitute those doctrines for in pari delicto, and that's a very important distinction because what the Superior Court did is, in essence, substituted in pari delicto for comparative negligence in assumption of the risk. Even though Your Honor went through the facts, I think the facts are very, very important as to how the drugs were procured on this particular day. As the court noted, Zachary Ross was an individual. He was living in Scranton. His mother had a prescription for OxyContin fentanyl. She had cancer, and his mother and aunt recognized that her son had a very serious drug problem. And in response to that, they tried to do the right thing and called the pharmacy and said, my son is stealing my prescriptions, and put a specific limitation on the fact that he was picking up the drugs and stealing the drugs. And there was a specific limitation, and there's no dispute in the record that the aunt and mother placed a specific restriction that this individual could not pick up the drugs in question. It's on the computer records. And this pharmacy is not a CVS or an Eckerd. It's a small, independently owned pharmacy located in downtown Scranton. And the pharmacy did have a procedure for limitations as to who could pick up their prescriptions. The pharmacist, who was the prior owner, he's a family member who owned the pharmacy. His daughter then owned it. It was older. His own method for verifying who could pick up a prescription was voice recognition, which is ridiculous. He testified under oath that even though the pharmacy has thousands of customers, the way he verifies if the customer is the customer is he recognizes the voice. Doesn't check the birth date, social security number, or anything like that. And in fact, on the bag that was given to this who had an admitted drug problem, do not give to son. So the family try to do everything in their power to limit their son getting the drugs. And the pharmacy took this family's money and gave the drugs to the family. And there's specific codes and regulations that regulate the pharmacy. Now let's talk about what the decedent did that day, because that is why we're here, because that is what, in fact, why the case was dismissed. There was some discussion on the day as to there were some text messages between the two individuals regarding that the two individuals were going to try to secure drugs, that my client was going to try to find drugs from another source, but they were unsuccessful. And they had some off-color conversations. And there was clearly some conversations between the two individuals who were discussing about what happened. And there was some difficult language about money, and there was cursing. So what? They had some really difficult off-colored text between them. So what?
Counsel, it's Justice Donahue. I think we know what the facts are, more or less. Let me ask you this question. If the plaintiff in this case was the son of the prescription holder, would you agree that imperi delicto would apply?
That's a great question, Your Honor, and I thought about that hard, because I think that it's a policy. This court has said that for imperi delicto, there's a policy considerations that have to apply, and they have to determine what has to happen, and you have to weigh the two policies.
But my point is a little bit more focused than that. Does the doctrine of imperi delicto require that the plaintiff and defendant have a transactional relationship, for lack of a better word?
I believe there has. I'm sorry, I interrupted.
In order to weigh the conduct, does the conduct have to take place in the context of the same transaction or occurrence?
Well, I think the court said in the Allegheny case, the case where the creditors, that the plaintiff has to be an active voluntary participant in the wrongful conduct or transaction. So I think exactly what you're saying is that the plaintiff has to be an active or voluntary participant in the wrongful conduct or transaction, and there's just no evidence in the record to suggest.
Or at the very least, your argument would be it's a question of fact that would preclude summary judgment as to whether or not there was a transactional relationship between the plaintiff's decedent and Sheeley's pharmacy.
Absolutely, and I think, Your Honor, and I think, frankly, that the appellee made my point in their brief. When they said, in the appellee's brief, they said, quote, "It is clear that Albert could not have been harboring any plausible or reasonable pretense that the fentanyl had just been obtained via his mother's prescription with Albert's hurried assistance, because in response, Ross was jonesing." Well, that's all reasonable inferences at the summary judgment stage are supposed to be ruled in my favor, in the non-movement's favor, not in the defendant's favor, not in the movement's favor.
Mr. Schaefer, Chief Justice Baer.
Yes.
There is no material. Is there any material fact in dispute that, and this is a very tragic case, obviously, and there's no joy for anybody in it, but that Albert and his friend, whose mother provided or had the cancer in the prescription, that they engaged in, let's call it a scheme, because I don't want to use conspiracy, that has some legal connotations. But there was a proactive scheme between the two of them, not necessarily in a malevolent way, to obtain drugs because they were both hopelessly drug addicted and in desperate need of a quote fix, end of quote, and that your client was an active participant in that scheme, calling, collaborating, driving to get the prescription, driving back to the home, and then, and probably the most disruptive fact to your theory, actually eating the fentanyl, which is a violation of the Drug Device Cosmetic Act, at the friend's home. But so again, I sort of made a speech. I apologize for that. The question is there a material fact in dispute regarding these two acting in concert to obtain the drug and then your client use it?
Well, there's two questions, Your Honor. Yes, they did try to get drugs from another source that at a convenience store, but they were unsuccessful. They were unsuccessful to try to get drugs. In other words, the client, Zachary Ross, said, "Can you get drugs?" And my client said he'll try to call, and they were trying to get some drugs at a convenience store. And my client was unsuccessful. And then what Ross said, can you get me I can get a prescription at the pharmacy, but I need a ride to it. And that's all that's in the record for the Sheeley's transaction, for the Sheeley's, and I'll use your words, for the Sheeley's scheme, for the Sheeley's fraud. The only thing that's on the record is that Ross asked for a ride to the pharmacy. There's nothing in the record that Ross told him he was getting the prescription illegally. There's nothing in the record that Cody Albert knew that the prescription was not his. There's nothing in the record that there's no evidence that Cody Albert called the pharmacy. In fact, we know that he didn't because Zachary Ross admitted to calling the pharmacy. In fact, Zachary Ross was convicted of a crime and is now in jail for involuntary manslaughter as a result of his actions, as a result of this, because of what happened in this day.
Schaefer, Tom Saylor, wasn't there an alternative basis, an independent basis for the trial court's decision, namely that no duty owed by the pharmacy to the decedent in terms of the position of this case?
Great question, Your Honor. And in fact, when the case first came into me, that was the issue that I was frankly more worried about, because to be quite candid, I never heard of imperi delicto before this case ever came up. I never even heard of the term. I'll be quite candid with Your Honors. I never even heard of the term.
Well, be that as it may, what about?
So for duty, Your Honor, I think it's very, very clear that under the regulations, this pharmacist has a specific duty not to give when the regulation.
No, a duty running between the pharmacy and the deceased.
Well, it's all about foreseeability. It's all about foreseeability, and that's a jury question. In other words, it's up to the jury to determine if it was foreseeable. In other words,
for duty comes before foreseeability.
Well, Your Honor, I think for inquiry is whether or not for this court is determined if there's a relationship between the parties, the social utility of the actor's conduct, the nature of the risk imposed, and the foreseeability of the harm incurred, the consequences of imposing the duty upon the actor in the overall public interest. Here, Your Honor, what I suggested actually at the trial court level is what we have is the pharmacist is regulated and has a duty to make sure that drugs are not willy-nilly put out into the world. So if somebody, God forbid, put a loaded gun at a picnic table at a playground, is it foreseeable that a child is going to pick that up and there's going to be harm? That's no different here. Here the pharmacist was on notice not to put this dangerous loaded drug out into the world and to, in fact, not to give it to a drug addict. Was it foreseeable that he was going to give it to a friend that might take it? That's for a jury to determine whether or not what would happen. And so our court has determined, Your Honor, and what we have said over and over again, is only under circumstances, only in circumstances when question of foreseeability is undeniably clear that the court may rule as a matter of law that a particular defendant did not have a duty. Here, Your Honor, I think the defendant, or the regulations, the pharmacist had a regulation. The specific regulation says that the defendant if the defendant either knew or should have known that the prescription should not be given to an individual, and they knew or should have known, for crying out loud, the family called and told them not to give it to the defendant, to Zachary Ross.
Well,
And-
Mr. Schaefer, can I interrupt you for a sec?
Of course.
I don't want to get into the weeds on this. We'll figure your case out. The word duty is used twice in a classic tort analysis. You are correct in the Falls Graph versus Long Island Railroad sense that foreseeability gets the duty the second time. But the first time is a pure question of law, which is what Justice Saylor was saying to you. There's no liability if there's no duty. So you're a physician walking down the street, and you see a pedestrian who is stricken with a heart attack. And it's foreseeable that if you step over that pedestrian, he's going to pass away. You're still free to do that because you have no duty to that pedestrian. And I could give you 10,000 examples like that. And that's the only reason that I wanted to make the point is I think your response to Justice Saylor is not apropos. It's the wrong duty, and it's unfortunate the word's used twice in a classic court case.
I wasn't trying to. I'm sorry.
It's a matter of law. Does this drugstore have any duty to your client?
Yes, Your Honor. And what I was trying to say is it's a general duty not to dispense the drugs, and therefore that there is a general duty not that the duty is in the regulation.
Your position is, as a matter of law, the drugstore has a duty to the entire universe of citizenry by virtue of Pennsylvania regulations or statute. Is that right?
Correct, and that's regulation 49 Code 702718, which says that a pharmacist can not fill or refill a prescription of a controlled substance or a non-proprietary drug device if the pharmacist knows or has reason to know if it is for use by a person other than the use for one for whom the prescription was written, or will be otherwise diverted, abused, or misused. I mean, that's the regulation. That's what the legislature said.
Suppose you're decedent. Suppose Cody had survived the overdose
Yes.
and subsequently had been convicted of possession of a controlled substance.
Yes.
Would the imperi delicto doctrine prevent his action from going forward?
I do not believe so, because that is not part of he did not knowingly participate in the fraud or the transaction in getting the drugs.
Albeit that he's been convicted, albeit that he stands convicted with all the elements required for such a conviction, possession of a controlled substance.
Well, I think, and I'm I'm not a criminal lawyer, but I believe just in my understanding of the criminal law, it would just be possession would be the element of that crime. And in imperi delicto, as this court had stated for that principle to apply, you have to be a known and voluntary participant in the fraud. In other words, it's a fraud, not really. Now, what I was trying to say, Your Honor, is that what the Superior Court did in holding that, just for example, possession would really turn every single solitary case on its head. For example, there could never be a dram shop case in this kind of case. If the plaintiff was drinking, the plaintiff was over the legal limit, there could never be a dram shop case. If the plaintiff was speeding, the plaintiff was illegally driving, forget about it. It can't be a case. I could go on. Our imaginations could go wild as to every type of case which is really comparative negligence, or maybe assumption of the risk that would be imperi delicto. And I used the case in my brief that if the plaintiff is driving without a driver's license and gets hit by a drunk driver, in that scenario, imperi delicto, out of court. Now, there's no way that could be the proper application for this court.
Just real briefly, you may have answered this with Justice Donahue. I'm not sure you did. Assume that, let's say some scenario here where Zachary had some sort of claim against Sheeley's. Would that have been barred by imperi delicto or not, in your view?
I think, Your Honors, I believe that this court really, in this atmosphere, this court really should adopt a policy to hold pharmacies responsible. We have to weigh, this is not, the cases that were cited are 25, 30 years old. This Commonwealth has an epidemic of opioids. Are we going to look at cases from 30, 40 years ago? Or are we going to look at cases from 2021, which is really happening now? Are we looking at cases where pharmacists have an obligation and they know that drug addicts are coming into pharmacists and trying to get drugs and shouldn't be getting drugs? And here's a case, Your Honors, where this Zachary Ross, his family tried to do the right thing, for crying out loud. They called the pharmacy, put a limitation on it. They knew the kid was in trouble. He's 21 years old. He's struggling with drugs. The family tries to help him. And what they put on the bag, do not give
Mr. Schaefer, in terms of your client and imperi delicto, and you stress the facts, wasn't it the derma patch?
Yes.
Didn't your client break open the derma patch and eat the contents? How is that not culpability in terms of the conduct of your client?
That's 100%
vis-a-vis the pharmacy.
That's 100% comparative negligence, and I'm going to have a major hill to climb at trial, Judge.
No, but in terms of Justice White's question, he assumed an arrest. I don't even think you need an arrest. You take a patch, break it open, and eat the federal. You don't know that's illegal?
Well, I think that what the facts say that the Mr. Ross did, and then my client followed up.
But in terms of imperi delicto, which is the grant, isn't the culpability of your client to exceed that of the pharmacy? Or equal?
Well, Your Honor, I believe there still has to be some fraud perpetrated upon my client. Has to perpetrate a fraud upon the pharmacy, and he just didn't. There's no fraud upon the pharmacy. In other words, my client just simply by having the drugs didn't perpetrate the fraud upon the pharmacy. So I think that, Your Honors, we're stuck as the facts are on the record. On the record, my client didn't participate in, as this court has said over and over again. There has to be some voluntary and active participation in the scheme to get the drugs. And where did Cody Albert do that? I can guarantee you, if he did, Mr. Kunkel would. He's a very capable attorney. I know that. I can guarantee that he would.
Counsel, this is Justice Doherty. With regard to the questions granted, the argument appears that the doctrine can be applied to a survivor action. Share with me your thoughts on its application to the wrongful death action.
It would apply to both, I believe, because you mean for both the plaintiff and to the you mean
the father of the decedent, the parent.
Well, the parents would be obviously they would have lost the care and comfort society of their child, and that would be for the jury to determine. That's for the jury to determine. Again, these are questions that were taken away from the fact finder. All questions that go to the fact finder.
That's exactly my thought.
So I think what we're having here, Your Honor, we have to balance even the court, this court said for imperi delicto that the doctrine is subject to the appropriate and necessary limitations, and that's the Allegheny court case. The public policy matters have to be taken into consideration, and Your Honors, I'm no fool. When this case goes to trial, I've got some big hills to climb on comparative negligence, assumption of the risk. When I took the case, I knew that's what I'm going to have to battle with. But I didn't expect to be battling a summary judgment motion when I knew that these are the arguments I'm going to have to make to a jury. That, hey, this is what comparative negligence is. This is what assumption of the risk is. But this is for the jury to determine, not for the court to determine. And therefore, that's what the court has to balance, that public policy determination. And frankly, it doesn't even belong for the court doesn't even have to determine the public policy argument, because there is no fact on the record where my client did anything that had any part of the transaction with the pharmacy. There's just no involvement in the pharmacy to get these drugs illegally.
In counsel, it's Chief Justice Bear again. I think that's probably the key to the case. But I think you're reading this record or trying to construe these facts with a razor blade-like knife. I just think that fairly read with the inferences, there was, as I said before, and I don't know a better word, a scheme, a plan, participatory by both the gentleman who's now in jail and the gentleman who's deceased to go get drugs. And you described it yourself. They tried at one place and they were foiled. They tried another place and they got it. And I guess the inference is if they had not gotten it from this drugstore, they would have tried a third place because they were desperate to get drugs, which is in some ways, as you say, the Oxycontin or the opioid tragedy of our society. But still, it does appear that there was this concerted activity of the two to get the drugs. Now, is that fraud? Do you need fraud? I'm not sure. But I don't know that you can persuasively argue that your client was the innocent victim here.
Jack, all right, if I could just respond to that. What you just said is exactly my point. You said with all the inferences, all those inferences are supposed to go to my side. All those inferences that you just mentioned are supposed to go to me because I'm the non-moving party. You might be right when it comes to a jury, and you might be able to make those arguments very persuasively. The defendants might be able to make those arguments very persuasively to a jury. But at the summary judgment stage, as you have put it, as this court has put it, all those inferences are supposed to go to me.
Fair enough.
Thank you, Your Honor.
Questions from anyone? All right. Well, thank you very much, Mr. Schaefer. Mr. Kunkel.
Good morning, Your Honors, and thank you for your time and the accommodation under these circumstances. I know that we're running a little long, so I'll try to be very succinct. I think what Your Honors have touched upon with respect to whether there's a transaction, whether that's a critical and necessary element in the imperi delicto under that doctrine, I think it actually goes to the central question in this case, which of course is the other side of that coin, or the obverse of the coin, which is duty. And the fact that one is straining to say where's the transactional relationship between the decedent Albert and the drugstore bespeaks the very fact that there is no duty, because as for our common law notion, as articulated by Justice Cardozo, is that risk imports relation, and where there's no relationship between, in the example that we've already talked about this morning, the passerby or even the doctor on the street seeing someone who's in obvious distress and in need of medical attention, absent a relationship, either transactional, contractual, or otherwise imposed by law, there's no duty. And so the two meld together. So to the extent we're trying to strain and reach a relationship between Albert and the drugstore, this speaks the fact and underscores the fact that there's no duty in the first instance. Now, with respect to...
Donahue, on that point, did the Superior Court address the duty issue? Because we've taken L.M.J.R on one issue, which is the
they did not... I'm sorry, Justice. I don't mean to talk over you. It's the lag.
Did they decide the duty issue?
They did not reach that issue. They confined their analysis solely to the imperi delicto. But as I've cited in my brief, this court has the ability to affirm on any basis so long as it's supported in the record. And
or
so
we could demand it to the Superior Court to decide the issue if we rule against you on the imperi delicto, which is the issue that we took on appeal.
That is correct. I would not disagree with that, Your Honor.
Counsel, can I ask you a question about back to the imperi delicto and the interplay with the comparative negligence statute? Let me give you a hypothetical. The plaintiff is DUI. He is struck by another vehicle. His vehicle is struck by another vehicle. DUI is a crime. No question, he was DUI. Doesn't comparative negligence apply in that situation? Plaintiff is involved in an illegal act. Automobile accident occurs. Doesn't that go to the jury on comparative negligence?
Yes, Your Honor, and it would be per se negligence. It would be per se negligence.
Yeah, how is that
And
different?
the difference here is in that situation you have a direct harm, presumably, and this scenario has come up in an argument in this case in the past. So you have a person who's drunk, or an innocent person who is unlicensed, as plaintiff said, or let's just assume he's even intoxicated, but he's rear-ended by another driver. He's not seeking to. He's not predicating. The plaintiff in that circumstance is not predicating his recovery on the harm that is caused by his drinking. He's predicating his action on the harm that is caused by another tortfeasor who manifestly and directly caused harm to him.
But what if they both cross the center line? Let's say that there's a question of which vehicle crossed the center line. Still, the plaintiff is DUI. It's
correct.
Who caused the accident? Doesn't that go to the jury?
In that circumstance, as long as there's a question as to what the cause of the harm was, yes. But and that goes back to the question of what a summary judgment's all about. It's a genuine issue of material fact. A reasonable inference has to be drawn in favor of the plaintiff, not some hypothetical, crazy, speculative inference. So there's no dispute on this record, Your Honors, that the cause of death was the overdose of the fentanyl. And so then we work backward from there and we say, so how is the pharmacy then responsible for them? Well, the pharmacy should have then prevented this plaintiff from unlawfully ingesting fentanyl when there's no reasonable pretense and no plausible argument whatsoever that he thought that he was taking this medication under legitimate circumstances or even legal as opposed to illegal circumstances.
Counsel, this is Justice Doherty, if I may.
Sure.
Following as Justice Donahue indicated, the questions granted are only dealing with the doctrine. In Bateman versus Berner, Justice Brennan wrote that the plaintiff must at least bear substantially equal responsibility. And that is to apply the doctrine, separating the standard for summary judgment. If this doctrine is to be applied to these facts, Ross is the purchaser or the one who obtained the drug from the drugstore. The decedent's son had nothing to do with the transaction. How do you apply, or how do you argue that the decedent's son bore a substantial equal responsibility in obtaining the drugs when it was Ross and the drugstore? I'm having an issue trying to overcome that fact. It seems we're diluting the doctrine with the standard for summary judgment, which are two separate things.
Well, the issue is, what is the relationship between the plaintiff and the alleged tortfeasor? So that is the transactional relationship that we look at. So the plaintiff here has chosen his defendant as the drugstore. So what is the relationship then between the plaintiff and the drugstore? And what is then the comparative illegality as attributed and ascribed, and in this case admitted? There's no dispute with respect to the plaintiff. So in that relationship, that's the relationship we're concerned about here, because that's the plaintiff and the defendant. So is he in pari delicto? Is he an illegal act? Everyone who's looked at this has cited the statute and said possession of a controlled substance without a lawful prescription is clearly an illegal act. So his relationship then is with the drugstore and saying, well, the drugstore should have, as plaintiff's counsel is arguing, the drugstore should have done something to prevent this drug from leaving its pharmacy, the doors of its pharmacy, and it winds up in the hands of this individual plaintiff. So that's the relationship. That's the, in the heavy quotations, transactional relationship. It's not a commercial transaction.
Mr. Kunkel,
It is a relationship.
Mr. Kunkel, here's my concern. You just said it ultimately ends up in the hands of the decedent. How is that bearing a substantial equal responsibility? By your own admission, it's not an equal responsibility.
No,
The transaction is Ross lying and getting the drugs that belong to his mother for his own use, and he shared them with the decedent. So
I'm sorry, Judge. Justice, it's the delay. I'm sorry.
it's okay. Go ahead, finish.
Well, the issue is, again, for the doctrine looks at the plaintiff and the defendant. The plaintiff here gets the drugs. Where does he get the drugs? He gets the drugs through an intermediary. He's not involved in a commercial transactional relationship with the pharmacy. However, what the doctrine is concerned about is the relative position and the relative culpability with respect to criminality between the plaintiff and the defendant. The defendant here has done nothing criminal. Arguably, Mr. Schaefer's position is that they violated the act with respect to the pharmacy by not adhering to the statute. So you look at that and say, okay, well, is that evidence of culpability? And then you look at the criminality of the plaintiff and you say, is he equal or in greater criminal fault as compared to the defendant? And where we have here, the act itself is upon which the case is premised. It's the illegal ingestion which causes him to die. That's the criminal act. Just like robbing the bank with the gun, you can't say, well, the gun malfunctioned, I should be able to sue the gun manufacturer. You're engaged in a stick-up at a bank. You can't come back to Remington and say, you know what, your gun manufactured malfunctioned. And the criminal, we wouldn't say the criminal, well, he didn't buy the gun directly from Remington. He bought it from a guy on the street who in turn bought it at the gun show, who in turn bought it at the sporting goods store.
So what you're saying is illegal act. So are you espousing the theory that any illegal conduct precludes any potential for remedy for the injury suffered?
It's not just illegal conduct in the sense of a civil violation like driving without a license. It's when the cause of action is premised itself on the very conduct. So in this case, we have a drug overdose. The manifestly illegal use of a derma patch. By eating a derma patch, it's supposed to go on the skin with a very powerful opioid inside for no legitimate purpose other than to serve as a drug habit, as sad as that is. So it's that criminal act. You can't premise the conduct in the criminal act, and that's the cases that the Superior Court has cited, and we've cited, including the case from the Virginia Supreme Court, where you're driving a getaway car in the middle of a crime. You can't say, oh, in those circumstances, say, oh, well, I was involved in a car accident. And just, if I could, just another quick analogy to make really, which is the more apt analogy here. It's not a situation where we have a drunk driver involved in an accident with someone else. What we have here is the analog of a son going into the liquor cabinet of his mother and getting booze, giving booze to his friend. And the friend then becomes drunk, and the drunken friend then goes and crashes the car into a telephone pole, a self-inflicted injury. And then he turns around and wants to not sue the son, not sue the mother, but go back and sue the distributor, saying, well, you know what, you shouldn't have let that liquor out of your store, because there's the eventuality that someone could engage in illegal conduct and self-inflict harm. That's not the law in this Commonwealth.
Yeah, but
Counsel, if I might, as you said early on, I mean, I think what you're doing is conflating your duty argument with the imperi delicto argument. And, bad cases make bad law. To alter the pari delicto doctrine in Pennsylvania, which, as it stands now, requires a transactional relationship in order to accommodate these facts. Every argument that you're making goes to the duty of the defendant to the plaintiff.
Well, in that scenario, yes. However,
they're separate legal issues.
And the doctrine is, as we've styled it, moving away from the Latin, as we've also, as the Superior Court has articulated, is it's the principle that no man can premise his conduct upon an immoral or illegal act. That's the principle. We don't learn Latin in schools. It tangentially comes into our doctrines through law school and so forth. But as articulated in English, the Superior Court in previous cases got it exactly right, that you cannot premise your cause of action on an illegal or immoral act. And that's when it's a direct concept, when it's a direct basis for the cause of action, that's when the doctrine applies under its English formulation.
May I follow up, Chief Justice Behr? And we're about done. Is it your position, premised upon your answer to Justice Donohue, that, and to Justice Saylor also, that when the deceased ate the fentanyl patch, that's the in pari delicto, putting aside duty, putting aside fraud in obtaining it, and whether there was a scheme or no scheme, that the eating of the patch, which certainly is unlawful in Pennsylvania, raises this doctrine?
Yes, Your Honor, I think that stands alone, but certainly on this record, in combination with the scheme to illegally procure the substance, is also a part of the record in this matter. Again, and that's the res geste that we've talked about. It's not coming in under 403 bad acts, or it's not precluded under 403 bad acts, precisely because it's the complex history doctrine under res geste, as this court has articulated. So it's they're scheming. They're clearly in an endeavor to obtain drugs illicitly, and that in combination with the fact that this decedent ingested this drugs in a manifestly improper, let alone illegal manner, by eating a derma patch, all is in the piece that this is an illegal scheme that culminates in the illegal possession of ingestion.
I want to ask you one more time, because I think it's important when we sit down to write, because I don't know if you answered the question. Is it your answer that it's the combination of the scheme to get the drug and the eating of the drug that raises the in pari delicto argument? Or is it your answer that the eating of the drug in and of itself raises that argument?
I think it's the eating in and of itself, and the manner in which it was taken here through the ingestion is sufficient unto itself. Yes. In addition to that,
and therefore we, I didn't mean to interrupt you, but we're about done. Therefore, we would be writing that when anyone in Pennsylvania dies of a illegal drug overdose, that regardless of other facts and circumstances of how it came to be that they got the drug, et cetera, that they would not have a cause of action.
They couldn't sue a pharmacy from whom the drug was illegally procured by them, yes, or illegally ingested by them.
All right.
Can I follow up on that, counsel? Because I, in responding to the Chief Justice just now, you don't intend to limit you're not asking us to articulate some special standard in the pharmacy context, I take it. I mean, at least we're interested in some, I assume we're going to deal with something broader than just pharmacy actions, but I'm particularly interested in how we are going to articulate something that will guide trial courts in knowing when this is a matter for summary judgment and when this is a matter for a jury to determine comparative aspects of fault, comparative amounts of fault. And I thought earlier I heard you articulating something like a privity type of argument. The intermediary arguably defeating or not defeating the claim of the victim against the tortfeasor. Take a dram shop case. You have a guy who buys a drink and then hands several drinks off to a manifestly intoxicated person, and then that intoxicated person gets hurt in a crash, wants to bring an action against the bar. In your argument, then, can that not be maintained on the basis of in peri delicto, because like Cody, that person who got hurt was not directly transacting with the bar?
Well, the short answer to that is there would be no cause of action, because the cause of action under a dram shop requires the service of a visibly intoxicated person. In your scenario, the bar is not serving a visibly intoxicated person. But to speak to the broader question, how would we define the scope of the doctrine in these circumstances? It's exactly as it's been articulated, that no man or no person can premise his cause of action on an illegal act and an immoral act. And so the question is, where do we draw the line then as a practical matter with respect to illegality? And how we draw that is on the basis that you cannot, that's what I was trying to articulate, that you cannot base the cause of action on the harm that directly flows from your illegal conduct. So like the gun, like the driver who crashes himself into a pole because he's drunk, where it's your illegal conduct that is directly causing your harm, you cannot turn around and sue someone else in the antecedent chain of events and say, well, but for you doing that, I wouldn't be in these circumstances. And that's why it does become conflated with respect to the no duty in the peri delicto. But in peri delicto says we look at the plaintiff and we look at the alleged tortfeasor defendant, and we say, let's look at the relative culpability of those. And if you are engaged in a not just this summary offense, not just a civil offense, but a misdemeanor crime, and you're trying to get money because of the harm as a result of the commission of that very crime, you cannot recover in this Commonwealth.
Counsel, it's Justice Donahue. You just said something that I believe is just an incorrect statement of law. In peri delicto means in equal fault. So
yes,
I mean, in order to apply this doctrine, you are saying my client is equally culpable with the defendant. And therefore, we are not going to allow there to be any involvement in the court in that situation. I mean, it is not a weighing involved. I mean, weighing, that's where you get to the comparative negligence statute. In peri delicto, I mean, I believe it means of equal fault.
Yes, but the way that the doctrine's, again, under the Latin, but the way the doctrine's been applied, equal or greater fault. So in other words, if I'm engaged in a crime with someone, and then I want to turn around and sue them, and I might have committed 3 out of the 4 felonies involved in our scheme, I'm in greater fault than the defendant. But with the way the doctrine says, pox in both your houses, you're both equally delicto at fault under the law because you're both criminals.
Okay.
Any further questions from anyone? Thank you, counsel. Interesting case, well argued. We'll take a 5-minute break and proceed to the next case.
Thank you all.
Thank you.
The next argument is in the interest of YWB and NWB, appeal of J.B. Mother. Representing Mother is Mr. Michael Angelotti. Representing the Department of Human Services is Mr. Craig Gottlieb.
We granted allowance of appeal to define the concept of probable cause in accord with the Fourth Amendment and Article 1, Section 8 of the Pennsylvania Constitution within the context not of criminal law, but rather child protective services. The question is whether the Philadelphia Department of Human Services had probable cause to enter a parent's home to ensure that the home is capable of supporting adequately the parent's two minor children. Mr. Angelotti, feel free to proceed.
Mr. Chief Justice, good morning, Your Honor, and may it please the court. My name is Michael Angelotti. I represent the appellant in this case, and we're asking the court to vacate the order of the Superior Court and establish a probable cause standard that a county agency must meet before they search a home in Pennsylvania. Your Honor, entry into a home by the government is afforded the highest degree of protection under both the Fourth Amendment and Article 1, Section 8 of the Pennsylvania Constitution. The standard created by the Superior Court in this case is overly broad and fails to protect the rights guaranteed by both the state and federal constitutions. Everybody agrees that probable cause to search a home is a constitutional requirement. But in this case, the standard established by the Superior Court falls below that. It does at least two things. It broadens the scope of whom the government may search with their definition of child in need of services. And this is a definition that exists nowhere in the law or in the regulations. And the second thing it does is it eases the burden on the government to something less than probable cause, because it creates more of a sufficient reason standard as part of its totality of the circumstances test. The touchstone for any probable cause analysis is reasonableness, and this is enshrined in both the state and federal constitutions. The Superior Court writes this reasonable requirement out of the law. We respectfully request that this court restore constitutional balance in this area and establish a test for probable cause in a case like this that considers four things: the government's justification for a search, the extent of that search, the totality of the circumstances to include a nexus requirement, a reliability requirement, and a particularity requirement, and finally, to consider whether any alternatives exist to a government intrusion into the home. Thank you, Your Honor.
Can you just give us I don't think we want to write a checklist or laundry list of what must be done here. Certainly there's an important Fourth Amendment right, but there's also a compelling parents' patriotic right to protect children. Have you comprised some sort of definition for probable cause in this context, which would be a sentence, if you will, a fair probability that the child's in need of services and an evidence relating thereto is inside the home, fair probability equating to reasonability?
Your Honor, I would at least write into that sentence that a child is in need of general protective services, which is actually defined in the law, which precipitates the government's investigation in a case like this. When the Superior Court talked about a child in need of services, this is a definition that they sort of established but didn't define, and it's broad enough to encompass almost any child. So it takes away.
Go ahead.
It takes away, I think, the discretion of the court, Your Honor. And within their totality of the circumstances test, they incorporated the concurrence from a preceding Superior Court case, in re petition to compel, which was authored by Judge Beck, which talked about a county agency having sufficient reasons, establishing sufficient reasons to search a home, but not being bound by any other constitutional requirements. And the sufficient reasons test is not probable cause. And, Your Honor, we would ask that does not meet the protections of
Before I yield the floor to Justice Todd, just let me just add your thoughtful enhancement. Show a fair probability that the child's in need of a child protective services, and that the evidence relating thereto will be found in the home. Does that do it?
Yes, I believe so, Your Honor. So there's two separate types of reports which may start a child protective services investigation, general protective services or child protective services. And we would ask that the definition would include either of the two. Child protective services being a report of abuse, and general protective services being defined within the regulations as services provided for the family.
Hey, Justice Todd, I apologize.
No, thank you, Chief Justice. Mr. Angelotti, I'm struggling with your proposed definition simply because in many cases, such as this one, the goal of child protective services is not to enter the home because the child is in need of protective services, but rather to enter the home to determine whether the child is in need of protective services. I take it's your position that the latter argument just cannot be accepted?
Well, Your Honor, our argument is that in either case, the Constitution, both the state and federal constitutions, require probable cause before that entry into the home happens. And under our, not to give a laundry list, but under our proposed standard, I think there are other alternatives, especially in this case. So in this case, it started out with a report that mother was attending a protest and they weren't sure if the child was fed during a particular amount of time. And at some point, there was an allegation that perhaps mother was homeless, which they raised a little bit later. And under a reasonable standard, Your Honor, and under the totality of the circumstances, in this case especially, I think there's established that there wouldn't be probable cause because there's other alternatives that would exist to getting in the home. They saw, in this case, mother and father and the children entering and leaving the home. And the address that they found the family at was both in their own records and in the information given to them by the reporter in this case. And seeing all that would establish that the family actually lived there. So the totality of the circumstances, in this case especially, relates that the family was not in fact homeless. They lived where everybody thought they lived.
Well, it seems to me then, in answer to my original question, you are saying that Child Protective Services can never enter the home to determine whether a child is in need of services because there are alternative ways to determine that, and then perhaps they would have the probable cause absent entry to the home. There are other ways to determine that?
Oh, no, Your Honor, no. I wouldn't go that far. I would say it's certainly in many instances, I would concede that there would be probable cause to enter a home. And I would look at the factors. Like, is there information? Is that information reliable to conclude that there's something in that home that would lead to that conclusion? In this case, there were not allegations that there weren't utilities working or that the home was deplorable or that there was something inherently wrong with the home. If there were a confidential reporter say that said, look, I was in this home, I saw that there were unchained or dangerous animals that threatened the children, or there was no food in the home. If there was something reliable and particular about the report, then I think that would establish probable cause to look in the home. But simply now, I'm sorry.
No, I said I understand your argument.
Yes, sir.
Just on you, if I could just step
I had a quick follow-up on that.
Justice Mundy, you go, and then just John will go.
Given what you just provided, and if we're looking at a totality of the circumstances in a case-by-case basis, wouldn't it be important, particularly in this case, to consider the past history of this family and the fact that there had been issues with regard to the home and the welfare of these children in the past, such that one of the children at least had been in a foster care situation, waiting for the home issues to be remedied?
Your Honor, I think that's a great point. I think you're correct that past history should be considered, but I think it would be considered in combination with whatever allegations are put forth in a particular case. In this case, especially.
And to that extent, I know that the record says there were general protective services complaints, but I was unable, and I know we don't have the record, and I didn't request it because it was prior to argument, but I couldn't see anywhere where those complaints were in the record so that we might be able to look at exactly what was the basis of the complaints, other than they're characterized in the briefs.
It's essentially what's the only information I have, Your Honor, was what was which was provided in the record in this case. There was prior counsel on the case had been closed, and they're apparently confidential after they're closed.
And to the extent that the case in repetition to compel, that's really not applicable but distinguishable in this particular situation, because that really was based solely on the four corners of a petition and didn't involve a hearing. Is that accurate?
That is, I'm sorry, Your Honor, I believe that is a difference in the case, but I think a couple things about in repetition to compel that were important was they did establish that a probable cause standard was necessary to enter the home, and the actual opinion of that case, rather than the concurrence, analogized that probable cause standard to the standard required for a search warrant. And there's
Which
something
is
less. I'm sorry.
Totality of circumstances.
Yes, Your Honor. Yes, absolutely. But they do analogize it to a search warrant, which would be needed in a criminal case. And they do establish a nexus requirement, both in that case and DR, which was a subsequent case, which came to this court, but not on those grounds, on different grounds. In that case, also, the Superior Court established a nexus requirement. Those are both abuse cases, and they stated that, look, there's no nexus between anything in the report and anything that would be found in the home itself. So they held in both of those cases that probable cause was not present, and that the agency should not be able to enter the home. And we would argue that that same nexus requirement should be applied even when there's a hearing on the matter. The same requirements should apply.
Okay, thank you.
Justice Donahue, I'm actually sort of surprised by your argument. I thought that your concern was that there were two issues that were raised in the GPS report regarding this mother and the family. One, maybe they were homeless. I think you've established that they concluded long before the order was issued that the family wasn't homeless. And the other, that it was possible that the mother didn't feed this child for 8 hours. And I thought your argument was, what in the heck is anybody going to learn by a search of the home about that 8 hours of not feeding the child? Is that not what your argument is?
Absolutely, Your Honor. And that's
not the argument you've been making, though. I mean, you seem to conceded the point that an order can issue for the broad concept of the child is in need of services. I mean, the issue that brought this family, after 5 years of not being involved in the system, back to the court was the only remaining issue was, did she feed that child for the 8 hours that she was protesting before the DHS office? And I thought your argument was, there's nothing in that home that could answer that concern.
Yeah, yes, Your Honor, that's exactly my argument. I apologize for not being more clear. The child in need of services standard we argue is overly broad, and I was focusing more on that. It's exactly my point that, look, the fact that there was a report a month prior to the actual hearing that mother may not have fed the child for 8 hours. There's no nexus, and there's nothing in the home regarding that at all. There's nothing, exactly as Your Honor said, there's nothing that they can find in the home that would justify that.
Counsel, this is Justice Doherty. I have a question.
Yes, Your Honor.
Again, similar to Justice Donahue, I was somewhat surprised that you argued that prior history is permissible within this investigation. The question I have for you is, the anonymous GPS was that mother and family slept outside unknown amount of days, so I assume it was just overnight, 3 weeks prior to this report, and that she had been out with their child all day from 12 to 8, and nobody's seen whether he or she fed the child. That was it.
Yes, Your Honor.
So share with me, based upon that information, why is it necessary to delve into prior history of the family, knowing DHS, the organization, requested the court to discharge it because all those issues were resolved and over?
Yes, Your Honor. Your Honor, in this case, I believe concerning the allegations and the history doesn't matter. My only point in
That's not what you said, Jim.
Right,
You said to Justice Todd, the history does matter, which I find somewhat astounding. And I guess the question I have, what are you asking us? Because you were seeing, you technically just argued for DHS.
Yes.
So what are you actually asking us to do, and what's the basis for it?
Your Honor, my only point with the history is I wouldn't, as a general standard, and not necessarily under the facts of this case, there would conceivably be a history that would include allegations of abuse or something that might be relevant. If something's relevant, I wouldn't argue for a standard that would deprive a trial court or a judge of considering that. In this case, I don't.
The issue before this court is when we look at the four corners of the request, is there a probable cause? And I need to understand why your position is, because I intend to get DHS to answer this question, why would they incorporate information from the past for which they gave the imprimatur that the family was safe and not in need of treatment? So I'm confused. Other than bias and prejudice, a tribunal.
Right, Your Honor, I believe there's nothing in this case that's relevant in the history to the allegations themselves. In this case, I believe it was improper to consider the history because there's nothing necessarily relevant to these specific allegations, and that goes, I think, Your Honor, to the particularity requirement of what they're searching for, whether or not there was feeding the child on a particular day or homelessness. Nothing in the allegations, nothing in the past history relates to those allegations. So in this case, I don't think any of the history would be relevant at all, and in fact would, as Your Honor suggested, would cut the other way. In fact, DHS sort of put their stamp on this family, saying that everything was fine. So I think the history would cut against DHS in that.
Mr. Angelotti, Chief Justice Baer, just to follow up, it seems to me that the prior history is not legally irrelevant. Your better argument is, depending upon the length of time that's passed between prior history and current, the nature of the prior history, it goes to weight. And the argument would be, under these facts and circumstances, notwithstanding some technical relevancy, which is a very low threshold in the law, that not much weight should be subscribed to that. How's that analysis work for you?
I think that's a very good analysis, Your Honor. And I would, Your Honor, I would highlight that with one of the suggestions from a brief of amicus curiae, the Support Center for Child Advocates in this case. So I think what they're suggesting is much more broad and open. So that they advocated for considering the history of the case, and they included irrelevant criminal proceedings or accusations that I think are entirely overbroad and not relevant to or would be inadmissible to a proceeding like this and shouldn't be taken into consideration. And Your Honor, I think.
No, go ahead and finish your answer. I thought you were done.
Your Honor, I think the standard that you suggested is exactly correct.
I wanted to ask you
what standard is that, counsel? What standard is that? And I'm getting back to Justice Doherty's point, because the arguments that you're making here today are almost 180 degrees opposite of that which is set forth in your brief. I mean, the petition in this case dredges up criminal convictions that go back 25 years. I mean, are you suggesting here today that there is some relevancy to that information, given what the GPS report apparently indicated, because I have ordered the record and I have gone through the record, and the GPS report is not in the record, which is another mystery for all time, since that was the basis for this entire proceeding to commence.
Yes, Your Honor, I think you're correct that in this case, I think the history that was included in the petition is not relevant and shouldn't be considered. My only concession would be that in a different hypothetical case in which the allegations in the report were similar to some other history, that in that hypothetical case, it might be a consideration that a trial court would use.
Mr. Angelotti, it's Justice Todd. If you feel you've already answered this, please tell me. But setting the facts of this case aside, are you contending that the standard for probable cause in the Child Protective Services arena is different than the standard for probable cause in criminal cases? Because I think some of the Superior Court case law insinuated that it was.
Right, Your Honor, I'm saying that the constitutional standard of probable cause from both the Fourth Amendment and Article 1, Section 8 is the same across the board. So 2 days ago, the United States Supreme Court issued a case, and I have it. It was a case considering slightly different, the community caretaking exception, Caniglia versus Strom, number 20-157. And so I think that case highlights the difference. In that case, there were police officers involved, and there was a dispute between a husband and a wife. The husband made some allegations that the wife should shoot him, and he was eventually evaluated by a doctor. The police, in the meantime, went into the home and took the man's guns. He sued, and eventually the First Circuit said, look, the community caretaking doctrine applies. So there's no Fourth Amendment right for him right there. But the Supreme Court said no, and they looked at this community caretaking doctrine, which I think looks at a difference between criminal and civil issues, and indicates that the Fourth Amendment is the same across the board. This community caretaking exception is when a police officer is not acting in his law enforcement or criminal investigation capacity, but in a capacity of rendering aid, almost like a social worker. And it's used in different situations where there might be a motor vehicle that's broken down, someone that's injured, and they might need help. So it's almost like a social worker. And the Supreme Court, Justice Thomas issued the opinion, indicated that homes are different. In that case, there is no justification to enter a home under this doctrine, and it wasn't necessarily a criminal proceeding. So I think the constitutional standard applies across the board, which would be a two-step analysis. So people look at the difference between criminal and civil, and I think there's a two-step process here. The constitutional issue, which is whether or not there's probable cause to enter a home, and then when it comes to the criminal case, there's a consideration of the remedy, which is essentially the exclusionary rule, and that's the criminal aspect of it, whether or not evidence should be excluded because of the first part, the constitutional violation. So I think the standard is the same. It just comes down to a difference in remedy, if that makes sense.
Well, it does make sense, and that's why I think some of the Superior Court's language in the past cases has been somewhat ambiguous on that topic, because the Fourth Amendment issue focuses on the sanctity of the home.
Yes.
Not upon the reason you had probable cause or did not.
Yes, Your Honor. And may I believe that's one of our key arguments. And one of my opponent's arguments is that there was a minimal intrusion into the home, and it almost looks at the damages, or what's the problem. And my only answer would be that under the Fourth Amendment and under Article 1, Section 8, entry into the home itself is the chief evil that these provisions were drafted to protect against. And the entry into the home, the violation of the home by the government, is the damage in this case,
Counsel, could I follow up on that briefly?
Yes, Your Honor.
Is it your argument then that it is irrelevant as a matter of law that the entry here is in the child protective context and not for law enforcement motives? Is that your argument?
Yes, Your Honor, and I believe I understand my opponent's argument is that Child Protective Services, it's important. Protecting children is important. And there was a question earlier about parents patria and the interest of the government to enter the home. But, Your Honor, in this case, there were 2 children. If these same 2 children were raped or were murdered, entry into that home no one would question that probable cause was necessary for entry into that home. And a rape or murder is no less important than, in this case, there was a boarded up window or an allegation that the child wasn't fed on a certain day. So I think the fact that it's Child Protective Services matter, those same allegations could constitute a criminal matter, and there's much more serious criminal matters, and no one would question the constitutional standard in that case, Your Honor.
Just one brief follow-up on that. So is it your position then that the sole thing we should focus on is entry vel non? Just the question of whether entry is authorized or not, and we're not authorized to consider in the reasonableness assessment any limits the court might put on the search or that might occur on the search, such as you're only authorized to do a quick check for necessities, or you're going to abide by, in this case, the father's instructions to not go in the basement and not go in the living room. So in other words, it's just the entry, period, and no tailoring that can be done on the nature of the entry. Is that your position?
Your Honor, it's our position that the entry of the home is the constitutional trigger that triggers these protections by both the state and federal constitutions. And after that, it would proceed to a totality of the circumstances test to determine probable cause. And if in a hypothetical case, if there were allegations that there are a fair probability that something in the home necessitated a search, then probable cause would be met. But if, like in this case, if there's nothing in the home that related to the allegations in the report, then it's our position that no, the constitutional protections in this case would not permit entry into the home.
Mr. Angelotti, I apologize.
Yes, Your Honor.
I have a question. It's a little bit off base, but I want to take advantage of this to get your thoughts on this. Frankly, there was an argument in my chambers between me and some of my law clerks on the point. In looking at the Child Protective Services Agency attempt to determine whether there's probable cause to enter in the home, they wanted to talk to the children and client mother, and no prejudice to her, precluded that. If they had gone to the school or gone to the church or gone to the daycare, are they free to talk to the kids without violating any right of the mother, notwithstanding that she said, no, you can't talk to the kids in my presence? Or are they precluded from talking to the kids in your view?
Your Honor, I wouldn't concede that they were. I believe in other cases, the courts have held that questioning of children in different contexts would constitute a search. There are different standards in cases like that. There's the special needs exception, which indicates that standards in schools might be different. Administrative searches, things of that nature might be different. But I believe courts have held that questioning a child outside of the presence of. I'm sorry.
Yeah, well, that's certainly true in criminal law, but respectfully, I don't agree with you in terms of equating criminal law and civil law. I tend to hold Judge Beck's view and petition to compel, and I know you don't, and I respect that. Okay, well, I'll have to look at that answer.
Yes, Your Honor.
Because it seems to me you put the agency that has a parent's patriotic duty to protect the kids in a catch-22. They don't have probable cause. They can't get probable cause because the potential culprit, and with respect, the mom is precluding all avenues through which they can get probable cause, be it from doctors because of HIPAA, from the kids because of mom's refusal to let them to talk, etc. And so it concerns me a little bit that the state's really important interest in protecting the kids could be thwarted, not under the facts of this case so much, but generally.
Your Honor, respectfully, may I? So that's a good point, Your Honor. But I think in this context, so information from a doctor, doctors and medical personnel and even school personnel, they're mandatory reporters under the Child Protective Services law. So they would be mandated if they saw any indication that a child were abused or in the General Protective Services to call in a report. So just respectfully, Your Honor, I think that information would come in, and I think it would form part of the knowledge of the agency. And I think the case of in-rate petition to compel addressed this issue a little bit. They indicated that absent entry to the home or prior to entry to a home, an agency is free to investigate other avenues and obtain other facts in their investigation and use those to constitute probable cause.
All right, thank you. Good answer. Questions from anyone else? All right, thank you for your argument.
Thank you, Your Honor.
Gottlieb.
May it please the court, Craig Gottlieb representing the Aplt, Philadelphia Department of Human Services. I'd like to first focus briefly on the probable cause standard and then discuss the evidence related to probable cause. On the probable cause standard, and of course we agree that we do have to meet probable cause, we believe that the petition to compel court properly identified the probable cause standard, where the court said that an agency, quote, must file a verified petition alleging facts amounting to probable cause to believe that an act of child abuse or neglect has occurred. So in our case, the standard is probable cause to find that neglect has occurred. Now, what is the evidence for probable cause? I'd like to point the court to what we believe are the 5 relevant factors. First is the history.
Mr. Gottlieb, I appreciate you have your 2 minutes, but as you go forward, the key here is probable cause to search the house. And so I want to make sure that you didn't inadvertently skip some nexus between probable cause in this house.
Right. No, I did not, Your Honor. There does have to be a nexus to the house, and what I was trying to get into the evidence, but what the petition to compel court then goes on to say is that evidence relating to such abuse, or in our case, neglect, will be found in the home. And we certainly agree that there has to be a nexus to the home. We just think that there is a nexus to the home, but I did not mean to carve out that as part of the test. And on the evidence, and I believe the evidence I'm about to describe does connect to the home as well. There are 5 pieces of evidence, or 5 relevant factors I wanted to draw the court's attention to. First is the prior history, and I know that Justice Doherty has questions about the prior history, but I would say in this case the prior history is extremely relevant. There were substantiated findings that the home was infested with fleas, that the interior structure of the home was exposed, and that the home lacked hot water service and heat. These weren't allegations. These were allegations. These were specific findings. Factor number 2.
Mr. Gottlieb, this is Justice Doherty. Let's stop right there regarding those issues. You're making allegations, but it's fair to say that your organization, 5 years prior, with regard to those allegations, specifically requested the court to discharge the petition because the family was safe and no longer in need of services, correct?
Correct.
So what you're saying is, at what point or how long must a family be alleged free? Anonymous allegations. There's no time quantification here. Coupled by the fact that you received a GPS report. I don't know whether they were eating. And there might be there was an allegation that the project home worker spoke to the mom, and she admitted that, yeah, I have a house. It had burned down, but we're there. Share with me, with all of us, how that GPS has to do or relate to any of the prior allegations of infestation. Well,
so Your Honor, the allegations in the GPS were that, right, that there was the family had been sleeping out, that there had been a fire.
Well, stop there. There's only an allegation that the family slept out. There's no evidence on this record. So one would have to assume the family slept overnight. so that we're not going to exaggerate the facts. The facts are what they are.
The
So
allegations
the
of the family,
allegation that I read was that the family had slept outside PHA headquarters 3 weeks prior. So 3 weeks from this allegation, they slept out overnight. Now, how does that have to do with infestation or any of the allegations that DHS found it to be no longer pressing 5 years prior?
well, Your Honor, it connects in this way. We find out that the family is sleeping out, and maybe there's also an extended period where they're an 8-hour period where perhaps they're not being fed and there's fire damage, and that is enough to trigger an investigation.
Wait.
We're not saying-
Justice Todd, that was resolved before the search, before the attempt to search, wasn't it?
Correct.
I'm sorry, Your Honor. I'm not sure what you mean. What was resolved before?
That issue of homelessness was resolved before the search was permitted.
The issue of homelessness, yes, but not the issue of the adequacy of what was inside the home. And those issues certainly connect together, right? You have.
Where was there an allegation about the adequacy of what was inside the home? Maybe I missed something.
Well, I think that flows, Your Honor, just from the fact that they're sleeping out, right? If they're sleeping out, and
One night, because the mother said they were protesting. One night sleeping out, how does that connect? It's the nexus that I'm concerned about. How does that connect with the need to enter and investigate the inside of a home? You know, this is very similar to the case of DR, Fayette County case we handled back in 2020, where the issues before the Superior Court were entering the home was the probable cause, as well as a urine test. We took the case on the urine test issue, but the Superior Court held, and it's still a good case, that there was no nexus, because the allegations that they were acting on were that the father had been seen allegedly drinking and perhaps drunk out at an event, and one of the children was with him, and that somehow led DHS, or Child Protective Services Agency, to believe they then had probable cause to search the home. And what the Superior Court said was, there's no nexus. And that's how I view this case, and I'd like you to focus in on that nexus question.
yes, Your Honor. And I think it is important to look at the, as we said now a few times, the totality of the circumstances. And ultimately, the relevant evidence that this court should be considering is the evidence that was in front of the trial court when the trial court issued the order to allow the assessment. And the evidence before the trial court at the time of the order to allow the assessment was the past history evidence was there. And Justice Doherty, I'm not saying that the past history evidence alone was sufficient to go in. I'm saying that the past history evidence is a fair factor for the trial court to take into account. The trial court can look at that past history evidence and say, this mother had trouble taking care of this exact home. Let's see what else we can find. Then what else was there? There was the fire.
So in criminal law, you can't use someone's conviction that's stale after 10 years. Why are you able to incorporate a 25-year conviction? And how does that justify General Protective Services? What really I found astounding was I got that it was a GPS report, but pursuant to 3490.223, which gives specifically General Protective Services, they are services to prevent the potential harm to the child, and it enumerates, 10 of them? 11 factors. Which factor were you looking for? The child was without proper parental care control. It was with mom. Had they been placed in adoption? That's not true. Were they abandoned? Obviously not. Were they without a parent? No. Was the child habitually truant? We don't know. I could go through the factors. And what we have here that I find most frustrating is the government is asking to invade the privacy of a home the sanctity of a home, we have no problem as a court permitting that. They camped out in protest, exercising a constitutional right. I didn't see DHS sweeping up the children when we had a tent city in the city of Philadelphia for 6 weeks. I didn't see DHS running through the homes of these people, determining whether they had children there. But I see DHS running through or attempting to run through the home of a family based upon an allegation without any anonymous source. Because if we want to apply the criminal principles, maybe if you're familiar with criminal law, we'll go to the Pritchard motions. Well, we will allow parents to search or challenge the veracity of the confidential informant or the anonymous caller. And then that will create a chilling effect for people making anonymous phone calls. And then we may not get additional custody proceedings or dependency proceedings because a parent lost in custody. You and I and everybody on this court understands the vicious wheel we have here. You're asking this court to give our imprimatur for an invasion of a person's home based upon their actual protest. You indicated, the record indicates, she was a political activist. So we're to punish the family for political activism without more. Is that what you're asking us?
No, Your Honor. And what I'd like to try to get through is the fact that she was out 3 weeks before is only what started the process. We would not have gone in based upon just that. And I know I'm not persuading you that the past history is significant, but in our view, that was at least a factor to consider. But that wouldn't have ended the calculation either. We also heard word that there was fire damage, and the fire damage has a very direct connection to the home, Your Honor. We have no idea what the extent of the fire damage is, but we know there had been a fire. We went to the house to check out what was going on, and we saw a board. So it wasn't like we just went in. The sequence is we have the reports. We then find the past history. We check out the fire damage, and then we say, well, this seems like it could be a problem. The fire damage itself, we can't investigate the fire damage without going in the home. There's simply no way to do that.
Here's my concern, and I think I'm in line with Justice Dougherty and Justice Donahue in their previous questions. But it seems to me that when you say, and I believe I'm quoting you from earlier in your argument, you said they at that point, DHS at that point, can say, let's see what else we can find. Well, that is aberrant. I mean, to think that the standard for probable cause to invade someone's home can have in any part the motivation, let's see what else we can find, it sends a chill up my spine. And maybe you misspoke, or maybe I misquoted you, but I'd really like to hear your thoughts on that.
Yeah, my apologies, Your Honor. I did not mean let's see what we can find by assessing the home. I meant let's see what we can find by continuing our investigation before we try and go in the home. In other words, I'm following the exact instruction that DR and the petition to compel court can tell us to do, that when we get allegations, we can't just go in. We need to corroborate the allegations. Let's see if we can corroborate the allegations. So I apologize for that confusion, but I think it's entirely appropriate for us to attempt to corroborate the allegations.
How, though, in this case, how did you attempt to corroborate them before you sought to enter the home?
Well, we did check on the past history and found that was very concerning. We did go to the house. We tried to talk to the children. We couldn't. We saw at the house that there was there were a boarded up window. Then those together are troubling. We then went to the court, and one factor that we haven't been able to talk about yet is the court has one tool that none of the rest of us have, which it can evaluate the mother's demeanor. And the court heard what the mother had to say and found that the mother was attempting to refuse to answer the court's questions. That is also a relevant factor in the analysis. In fact, the trial court has to have some discretion to evaluate what the mother what the mother's capable of doing based upon the mother's expressions and demeanor in answering the questions.
Mr. Gottlieb, it's Justice Doherty again. I understand exactly your argument, but the question I have is, if mother is being dilatory or belligerent or precluding access, why would you not just request a dependency petition be filed so that the court now is involved and the standards change, in which a dependency petition in determining whether 6302 has been met, the court now has the ability and the necessity to take in the history of DHS, the prior convictions. The law permits us, as the trial judge, to do that when you have a petition for dependency existing in front of us. But you're asking us to incorporate all the rules in the evidentiary parts of an adjudicatory hearing to be kind of wiped away because you want this free dependency petition investigation tool of walking through the house. That's where my issue lies. So share with me how we can compromise, or how this court can best understand. I wholeheartedly agree DHS should know the history, or I should say DHS's history of the family should be made known to the court once a petition has been filed and either the child is or is not alleged dependent, and if so, what is the appropriate disposition?
Your Honor, I'm not sure I know the sequence, but I assume it would go in the I assume that we were trying to go in the opposite order. In other words, make sure that we understand what the specific facts are. In our view, we have probable cause to find evidence of neglect. That's the standard of what we're trying to do. And then once we find that evidence, then we could file a petition. That also happens to be exactly what happened in, I can't remember if it was DR or petition to compel. It was one of those two. I think it was petition to compel, where the claim was that, shouldn't you have filed a dependent? The claim was, the answer was the issue was exactly the one you're raising, Your Honor. And,
correct.
And the court said, you can file the petition to compel prior to you filing the dependency petition, which is what we did.
But what you're arguing to this court is definitions of dependency, which means based upon your allegations, you have sufficient evidence or verification to file a dependent petition in a court, which changes the rules.
No, Your Honor, I think we're arguing in the opposite order. We're trying to find the evidence, but we have probable cause to believe that evidence may be in the house.
And what evidence is it? I'm sorry, but what evidence is in the house with regard to camping out and protest?
Well, with regard to camping out and protest, there's none. But as I'm saying, Your Honor, you have to look at the totality of the circumstances. And here, the claim was that there was an inadequate care in the home related to the structure, inadequate care in the home related to food, inadequate care in the home related to utilities. And
can I jump in there? Chief Justice
Bear, can I ask a question? Why is the GPS report not in this record? You are stating as fact allegations made in a GPS report that does not appear in the record. What we know is what's in the petition, and there are two things: homelessness and didn't feed the child for 8 hours. Where is the GPS report? How do you go to a hearing based upon allegations in a report and not have the court with the ability to look at the GPS report?
Your Honor, I'm not sure why it's not in the record, but I do want to try and get one point across, which is that we're not saying that we had the right to enter based upon the allegations of 3 weeks ago. We're just saying that started our investigation. What we are saying is that we had the right to enter based upon the results of that investigation.
Mr. Gottlieb, can I jump in?
Please.
Because this is very, very much in furtherance of Justice Donohue, Justice Doherty, Justice Todd, would you agree that records from 25 years ago are probably irrelevant, or at least entitled to extraordinary little weight given the passage of time?
Yes.
Okay, so let's then get rid of those and forget about them. Let's talk about the averments of, I think it was about 5 years ago, which is when the kids were adjudicated dependent. The house had burned down, did not have interior walls, had all sorts of other problems. Is that accurate?
Yes, although I'm not sure the timing of the fire is accurate, but the lack of interior wall part is accurate. Yes.
And I thought that the fire, and I may, again, we have lots of cases and we try to get ready the best we can. But I thought the fire averment was part of the dependency 5 years prior. Do you recall that?
I'm not sure when. It's a little bit hard to tell. What I do know is that when the social worker went to the house, the home was still boarded up. So it's possible it stayed that way for 5 years. I'm not sure.
Yeah, well, and that's what bothers me. You surely don't advocate a rule that because there was a prior dependency, which was happily resolved with return of the children and dismissal of dependency, that prior dependency gives you probable cause to check on the home into the future, or a prima facie case, to use a criminal term, to check on the home into the future. It seems to me that it would be relevant, but I don't know how much weight it has unless you're going to stigmatize mom and father and family after, as Justice Doherty pointed out to you, you've absolved them, you've congratulated them on correcting the problem that caused dependency and returned the kids. And it seems to me that the linchpin of your probable cause argument here has to be the dependency, the resolved dependency of 5 years past. Now, am I missing something?
I think it is part of the totality of the circumstances that alone, and that's why I'm not sure that we can connect the fire.
Again, let me just interrupt you because our time is short. You can't seriously advocate that the fact that she slept out of her home 8 hours protesting the Philadelphia Housing Authority has some nexus to the home, or some nexus even to dependency in and of itself. So what else do you have to argue probable cause to us than the dependency of 5 years before?
The fire and the demeanor.
The demeanor. Yeah, you know what? And this is a little far afield, but when I was as others on this court were, I was a trial court judge for 13 years. I was in dependency for about 7 years, and I probably did 10,000 of these hearings. I think that mom was obnoxious. I think that she's in a battle with authorities, perhaps justifiably, and I think she ticked off the trial court judge, and that's what actually spawned this whole thing. So I would actually agree with your demeanor argument, except that the trial court judge probably, and this is, I'm not sure I wouldn't have reacted exactly the same way. I'm not criticizing the trial court judge. But what this is probably about is that he got short with her because she was so difficult with him.
Your Honor, I understand why you say that, and that is certainly a very logical reaction, but I think ultimately that, respectfully, that is the trial court's call, right? The trial court, not me and not you, the trial court sees the mother's reactions, and the trial court is allowed to look at her reactions and say, make credibility determinations. That's all I have to say about that.
Yeah, it gets to say, go into our house and search it, but that's okay. I understand your argument. Very well done. Does anybody else have any questions at all? All right, good job.
Job well done.
Yeah, it's a important case. We'll take it under advisement. We'll take a 5-minute break and do another case. For all the justices, I'd love to finish in the morning. We'll see how this next case goes.
Hey, John, do you have any update?
I'm just checking with Aaron. Just give us like 5 more seconds just to make sure it's staying here.
Okay. Does it look like we're going to need to distribute new links, or?
No, we're showing the stream live now, and I mean it's back up on YouTube as well. I think you're good to go.
Okay, it sounds from Stacy like we're live, so Aaron, if you wouldn't mind.
Well, let's go on again.
Doing this real quick.
Yeah, just let me know when you're ready.
We are.
Oh, thank you. Here's just one article. Not give you this. Thank you for doing that.
The next argument is Protect PT versus Penn Township Zoning Hearing Board and Olympus Energy. Representing Protect PT is Mr. Timothy Fitchett. Representing Penn Township Zoning Hearing Board is Mr. John K. Sweeney. And representing Olympus Energy is Mr. Blaine A. Lucas.
Happily, Olympus Energy applied for special exception to develop and operate unconventional gas wells at 2 well pads in Penn Township, Washington County, Pennsylvania. Appellant Project PT objected to the grant of the special exceptions. Following several hearings at which both parties presented expert testimony, appellee Penn Township Zoning Hearing Board granted the special exception subject to various conditions. In so doing, the board concluded the Project PT failed to establish sufficient evidence that the proposed well will be a substantial threat to the health and safety of the community. After the Washington County Court of Common Pleas affirmed, Project PT go to the Commonwealth Court asserting that the Zoning Hearing Board had capriciously disregarded the evidence presented by Project PT. The Commonwealth Court affirmed. We granted review to consider the Commonwealth Court's application of the capricious disregard standard and also to consider the relevance of the cumulative impact of developing multiple unconventional natural gas wells in close proximity to residential areas. Mr. Fitchett, please feel free to proceed.
Your Honors, and may it please the Court. The main issue with regards to the capricious disregard of evidence standard that I want to talk about today is whether or not this Court is going to allow and sanction the use of credibility determinations to essentially avoid any real appellate review the decision that was made below. The precedent set by the Commonwealth Court and by this court does give a lot of deference to the fact finder, and essentially says that any credibility determinations can never be overturned. It is for the fact finder to decide. What we're concerned about is that credibility determination and that deference can ultimately be sort of abused in the sense that the evidence presented by, in this case, Protect PT, can be sort of all completely thrown to the side under the auspices of a potentially pretextual credibility determination, and avoid any meaningful appellate review, which I think is exactly what Judge McCullough was concerned about in her concurrence at the Commonwealth Court in this case, when she stated her concern that the appellate review process was purely limited to ascertaining whether the board had made a credibility determination about the evidence that had been presented to it and the expert witnesses, or the witnesses generally, that had been presented to it. And I think it's especially concerning in cases such as this one, where that credibility determination has essentially been used to, again, completely push aside the evidence that had been presented by Protect PT, evidence that involved scientific studies, peer-reviewed studies, a preeminent scholar on public health in Pennsylvania. Dr. Sue is a doctor with many years of practice and decades of work in this public health field. And for the Zoning Hearing Board to essentially say, to not have to grapple with the science that's presented, to not have to grapple with the facts, to give any kind of meaningful explanation, and instead be able to use this credibility determination to avoid any review, we think allows for potentially arbitrary and capricious decisions.
Mr. Pritchett, it's Chief Justice Fair. You're attacking an absolute bedrock of appellate law in the United States, which is that we don't see the witnesses. We read a cold record, and credibility goes to the trial court, or in this case, the administrative hearing apparatus that sees and listens to the witness. And I just don't see how that attack is workable. They wrote 138 paragraph decision, 22 pages. I mean, I'm not sure. Can you put meat on your bones? Do you want them to say he was perspiring, he had a nervous tic, he didn't look at us? I mean, because they'll do that. I don't know that you're going to overcome the credibility assessment of the board. You're not arguing that it was unfair or prejudiced or biased or there was fraud. Those are different arguments, which obviously would get our attention. I think you're respectfully Don Quixote tilting at a windmill to try to say, well, there may not be enough in credibility, but I don't see how it changes anything, and I don't know what you want.
Thank you, Your Honor. I think that we do have some backstops with this capricious disregard of evidence standard. With, Taliaferro says that there shouldn't be a complete and baseless disregard of the evidence that was presented. There should be a meaningful explanation as to why evidence wasn't reviewed. These are within the precedential standards, but using credibility determinations to say that all of the evidence was not credible, as opposed to having to go through that meaningful analysis to tell the individuals what science was believed versus what wasn't believed, that is all sort of circumvented through the use of this credibility determination. And
Could I follow up then, counsel, on that? Because you began your argument by citing a, quote, potentially pretextual, unquote, adjudication, seeming to me to put the bunny in the hat. I guess you're inviting us to assume that the board imported, or perhaps the trial court beyond that, imported some pretext, but to use the chief's term, I don't see any meat on those bones, and I'm not clear on how you're going to show us that Dr. Tsu's evidence overwhelmingly and indisputably established that these operations or these proposals were so beyond the general run of these type of operations as to compel us to put aside the credibility and fact-finding of the people who heard and saw the evidence. In other words, why is your case so different from every other case we review in an appellate posture?
Well, I believe that the situation that arises here, especially when it's a zoning hearing board as opposed to maybe other appeals that work very hard, and I think there's a chilling effect when all of that work to put forward scientific evidence, to put forward reports, to put forward witnesses, when all of that is simply able to be brushed aside through a credibility determination, as opposed to a more meaningful explanation and rationale to describe what it was wrong with the evidence to help these groups actually figure out what is it that this board wants to see, what would help with the next well that goes in to be able to show. And none of that is available. And so I think there's a strong chilling effect when those explanations and those reasons are missing.
Council, may I? Oh, I'm sorry, Justice Donahue. Go ahead.
We took this case because you suggested that what the Commonwealth Court did in this case conflicted with other opinions. What opinion is that?
Well, I believe that it did not comply with the Taliaferro standard. So Taliaferro does require that there not be a complete and baseless disregard of evidence. And I believe if you look at the findings of fact and conclusions of law, that their description of Dr. Tsu's testimony is false. It's wrong. They imply through their explanation that Dr. Tsu only spoke about self-reported symptoms, and the implication is that one of the reasons why they found him not to be credible and that his evidence was not sufficient.
Counsel, and I spent a tremendous amount of time on your briefs, the briefs of the the other parties. I looked at the record, I looked at the expert reports, and the capricious disregard standard is what it is. What you're arguing in your briefs is something you never raised anywhere before in this case, which is that the board's findings of facts were not sufficient. That's not a bad argument, but nowhere along the way in the trial court or in the superior court did you make that argument. And so, I'm groping, and I think this might tie to Hinkle, which you don't mention, which is the case I thought you were going to argue set forth a different standard, but I'm struggling with what precisely the issue is that you want us to determine. We are here to correct an alleged error by the Commonwealth Court in its review of the evidence. And if that's what you're asking us to do, that's somewhat of a fool's errand. So in terms of the evidence that you presented, which it found to be both insufficient and not credible, where was that challenge raised?
I'm afraid I can't point to a specific place in the record at this moment.
Because you can correct me if I'm wrong, that is what your argument to us is, at least as set forth in your briefs. The zoning hearing board isn't giving us enough information as to what we're doing wrong, which is not precisely what their job is. But I think that's what your argument is. And that issue has not been preserved anywhere in the record in this case.
I
could be wrong. I'll take another look, and of course, all of my colleagues will do the same. But that really is the wall that I hit in going through the record in the briefs in this case. I know Justice Todd had a question.
Oh, that's quite all right. Mr. Fitchett, let's assume for the sake of this argument that there is not a preservation issue or a waiver issue. We'll certainly get to that on our review post-argument. But I had two concerns about the position you're taking today. One is, and I think Chief Justice Behr alluded to this, credibility deference by the appellate courts to the findings of fact of a trial court or a board, a hearing board, constitute a bedrock principle of our methods of appellate review. It would be rare for us to overturn a credibility determination by a lower court and or tribunal, and we would only do that if the record clearly did not support the finding. And with respect to credibility, that's really a Don Quixote attack or attempt, as the Chief Justice said. But moreover, you seem to be asking us to require judges of the trial court and hearing board officers to delineate all the specific reasons why they found a witness credible or they found a witness not credible. And I would submit to you that by and large, our cases never have that. Opinions by judges say, I looked at him, I found him to be not credible. They never say, or rarely say, because he squirmed, because he winked, because he blinked, because he scratched. They don't go into that. They usually just say, in my judicial opinion, which is what counts for the trial court, I did not find him credible, or I did find him credible. So that's one of my concerns, that you're asking us to require a delineation that we never require. And secondly, I guess I'm concerned about your accusation of pretext, because it seems to me you're alleging that a hearing board, or maybe the court, the lower court, I think you're pointing just to the hearing board, was giving pretextual reasons for its decision, which that's a serious accusation. If that were true, I think we'd be talking about misconduct. So those are my two questions, and I'm sorry it was such a long exposition, but the one is, do you want to are you trying to require us to delineate the basis for credibility findings? And number two, are you alleging misconduct?
So on the first point, I'm not saying, and I understand the difficulties and essentially the impossibility of looking at a witness and for a judge afterwards or a fact finder afterwards to delineate those considerations. But when it comes to the scientific evidence that was presented, then I think that scientific evidence, as presented by Dr. Sue, by Nurse Dagley, explaining the potential harmful effects, I think that there is an inherent credibility to those studies that does warrant more than a cursory, we did not find this evidence credible. That, it doesn't seem, when you're taking peer-reviewed studies that have passed numerous levels of review by other scientists, by experts in the field, to then be published in a journal, for a zoning hearing board to just say, well, I didn't believe it. I think— Were
they uncontradicted, Mr. Fitcher?
In some of the cases, at least some of the evidence we do believe was uncontradicted, specifically the evidence regarding the cumulative impacts.
Well, wait a minute. Can I jump in there? Because I thought the board chose to believe, if we want to use that term, or to accept Dr. Long's evidence over Dr. Tsu's. I respect the fact that you are really, really upset about that. But the fact that you're really, really upset about that is no basis for us on this stage of the process to come in and say, you know what? We're just going to assume there's some dirty business here. There's some sort of pretext here. Perhaps had Dr. Tsu or your other evidence established something specific about these operations rather than about these kind of operations generally, you might have had a different result, and then we would be deferential, presumably, to your side of the case. I'm still struggling for a standard that you can offer us why your case is such an outlier, so special, that it compels us to apply this capricious disregard standard.
And Justice Wecht, may I also ask that Mr. Fitchett answer the second half of my question as well?
Sorry about that.
That's
Excuse me.
I'll try and keep everything straight. So in regards to the assertion of pretext, and I did not mean to assert that in this particular case that they were, in fact, that there was any misconduct. But I think that the current precedent and the current standard allows for that to happen due to the deferential standard. If they can simply say that all of the evidence presented by the party that was opposing whatever decision that they want to make, if they do not have to get into the depth of why they made one decision over the other, why they decided that to believe this expert's evidence over that expert's evidence, then it allows them to make whatever decision that they want that is potentially arbitrary and avoid any real appellate review, which again is what Judge McCullough, I think, was concerned about, that it's just a matter of determining whether there was credibility concerns and not having to go into the deeper, meaningful explanation of why certain evidence was chosen over another.
okay.
And Justice Wecht, if you wouldn't mind, I'm sorry, repeating your concern.
It's too lengthy for me to repeat it. I'm still going at the standard of review issue and why your case is such an outlier as to compel us essentially to displace the capricious disregard standard. They believe long over two. These are the kind of judgments fact finders make all the time. They made their credibility finding. You're insinuating that there's something underhanded here, and that can happen. But again, going to the meat on the bones metaphor, where's the meat on the bones? Are there affidavits? Somebody got paid off. There's a bribe. It's not enough to just come to this court and just say, this is a dirty business. Something's wrong here. Make it right for us. That's not how courts work. Are you asking us to throw out Taliaferro? Are you asking us to, is there something in federal administrative law you want us to bring in? It's not enough to just say, this is really bad. Dr. Tsu's a great guy. It's so wrong that he wasn't believed. I'll stop there. I think I'm repeating myself.
So, I mean, we do believe that under Taliaferro's standard that the zoning hearing board did not actually meet that standard in this case, and that the approving of the decision, despite that, failed. They did not actually, they did capriciously disregard the evidence presented by Dr. Tsu by essentially not discussing and not explaining why the peer-reviewed studies, not the self-reported studies that they did discuss, were not actually reviewed. And then the other piece of meat on the bones here is the cumulative impacts that were essentially unrebutted by the opposing party. And I think that the cumulative impacts were spoken about by both Nurse Dagley and Dr. Tsu, who said, when you have these overlapping effects, those increases are going to be, the increases in health impacts are going to be exacerbated. There's going to be a different health impact there. And normally that would, under the fluorine standard, that is meant to change it's supposed to shift the burden back to the applicant to rebut that evidence. And
Tom Saylor, you referenced several times Judge McCullough's concurring opinion. It's very brief, but I've read it and I don't understand it. He says She's concerned that this court functions merely to ascertain whether a zoning hearing board found the objector's evidence credible. There's much more to the standard review than that. I mean, you're familiar with this pretty well invented Pennsylvania law. Why would she say that's the only function of the Commonwealth Court? You know, because capricious disregard, you review it for capricious disregard, and that's a willful and deliberate disrespect or disregard, competent testimony, and relevant evidence, which one of ordinary intelligence could not possibly have avoided in reaching a result. And you have Wintermeyer. And it's the obligation of the reviewing court to determine whether there's substantial evidence to support an agency's factual finding. And those findings in turn support the conclusion. So when she says that's all we're doing these days, I don't understand what she's talking about.
Well, I think this gets back to...
So you keep saying there's a capricious disregard, but I'm just getting into the elements of that. And that has to be your concern, that that's not enough.
I think that the concern is that the credibility determination itself can be used to avoid having to go into, was there substantial evidence to support the decisions on the facts as made by the zoning hearing?
Well, that may be a problem then if you can show that a court did that. But that's a different issue. You understand what I'm probing? Sorry, this is Tony.
Oh, that's okay, Justice. We have a somewhat of a developed question in order to decide the issue of capricious disregard, and that is whether a reasonable mind might make the same decision on the evidence before the agency. I mean, what's wrong with that as a test for a capricious disregard? I mean, I think all of us have taken a look at the expert reports that were proffered on behalf of your client, and whether you call it sufficient or use some other terminology to describe it, the question for a reviewing court is, could a reasonable mind make the same decision as the board did? And I think the answer from the Commonwealth Court was yes. The answer from the trial court was yes. I mean, it is a deferential standard, and the question is pretty straightforward. So, I mean, should we be tinkering with that analysis that we've used to determine capricious disregard for the evidence?
I do think that in these cases, in these zoning hearing board cases, that it would be useful from at least a public policy standpoint to require more of an explanation than we did not find that this was credible and we did not believe in this science.
But you're asking for an explanation by the board, are you not?
Yes, sir.
Okay.
Mr. Fisher.
A legitimate issue, but that's just not, it just was never brought before the trial court or the Commonwealth Court. I mean, I understand your point. I've read the findings of fact and conclusions of law. I mean, there really are no findings of fact. There's a recitation of what the testimony was. As a matter of fact, the board didn't even credit one of your witnesses as an expert. The conclusion as to your client is one paragraph. Your client's evidence, not credible, not sufficient. And I think your point should have been all along is those findings of fact and that conclusion is insufficient. I mean, we have a statute that requires that local agencies set forth the reasons for their conclusions. But see, that's really just not the issue that we have captured in this case anywhere along the way. The Commonwealth Court may have agreed with you on that. Why should we have to parse every single page of this record to see if there's anything there to support what the local agency did? They should be telling us what supports it. But am I capturing what your problem is? I mean, I'm looking at this, more forward-looking.
Yes, I think that is a good encapsulation of what the issue is, and I believe that we did preserve these. We've been discussing and bringing up the capricious disregard of evidence, throughout, but I'll obviously have to defer to your court's review of the record and whether we have properly preserved that issue.
Mr. Fitchett, Chief Justice Fair, I agree with Justice Donahue, but I think your problem goes far greater. I think the problem is a political problem, which is that you need to take over Penn Township. They set aside 10% of their land for fracking, leaving the other 90% intact. And I think that the way this record reads to me, that your client is absolutely opposed to any fracking anywhere all the time. But because of the Penn Township allowance of it, all that's required by the fracking companies is the special exception, and there's the phraseology goes, it's neither special nor an exception. So if I look at and I don't think that anybody found your evidence not credible. If I look at paragraph 37 of the adjudication on page 19, it says that the applicant Olympus has produced sufficient evidence, subject to some conditions, to satisfy the requirements of the ordinance. So that shifts the burden. And then if I look at 38, the objection party to fail to establish sufficient credible evidence that the applicant has been found to have, once the applicant has been found to meet the ordinance requirements, that there would be a high probability that adverse, abnormal, or detrimental effects will occur to public health, safety, or welfare. So you have, because of the politics, because Penn Township has chosen to allow this, your evidence may well be credible, but you don't meet that really high truth bar that the detrimental effect to public safety and welfare is proven by high probability. And again, if you look at Dr. Sal's testimony, he's an eminent but just reading this record the best I could, eminently qualified. But he also is 100% against fracking all the time, which does impact his credibility when he's testifying on a peculiar project. So I guess what I'm saying to you is it's not accurate to say that assuming the issue was raised, that your evidence wasn't credible. It wasn't found credible enough to meet the requirement that you have to meet to overcome a special. Don't you think that's fair?
I certainly understand your point if I do disagree with the conclusion.
Thank you. Anything further? All right, we have two counsel on the other side. My note, Mr. Sweeney and Mr. Lucas, feel free to argue in whichever you prefer. Please do not repeat each other. And if we ask a question to the first to argue that's better suited for the second, feel free to tell us that.
Thank you, Chief Justice Baer. Mr. Lucas and I have divided our arguments. I'm going to handle the issues of the board's fact finder role, the standard of reviews for zoning hearing board decisions, and the capricious disregard issue. And I think Chief Justice Baer encapsulated our view of this case very, very succinctly. That the board undertook an analysis of expert testimony here. I'm sure all of you that have been involved in trial practice, if I have called experts who have magnificent credentials and dozens of publications and experience in testifying, and they present their evidence and they testify and they render their opinion with a degree of certainty in their profession, and the fact finder comes back and says, no, it's not enough. You haven't met your burden, or you haven't undermined the burden of your opponent. And frankly, at the base level, that's all this is. That's all this case truly is. To argue that this board capriciously disregarded evidence that came before it really has no merit or foundation. Both these decisions were supported by sufficient evidence of the record. This board didn't commit an error of law. It didn't abuse its discretion. And That's the standard that should govern the review of these two cases. The Commonwealth Court, when it rendered its opinion, didn't create a conflict with its prior assessments of capricious disregard application. And there's a reason that's supported in the record for this. There's no overwhelming evidence that would compel and create a situation that's clear and without doubt it would command a different decision by this board. That evidence isn't there. And you know, I direct your attention to the reproduced record of the Gaia testimony from Dr. Sal, pages 369 to 380. You know, this board that supposedly capriciously disregarded his evidence spent a good 10, 15 minutes questioning him at the end of his testimony. And Dr. Sal acknowledged that in his questioning by the chairman of the board, that they did not have the studies of the caliber that Dr. Long had presented on behalf of the applicant in this case. He said we need to do prospective control studies, and he went on to explain that they're labor intensive and they're expensive, but they haven't been done yet. And that's when he segued into this argument that Ms. Dagley also produced about the decision should be based in some part or all on this precautionary principle of public health, that if the science isn't there yet, according to them, then you should err on the side of caution. And
Could I ask you, counsel, on that with respect to this legal question we have before us, the capricious disregard standard? Should we put meat on the bones of that standard, so to speak, and require these boards to give a reasoned explanation? Should we require more than we got here, rather than simply reciting what Dr. Tso had to say? Actually tell the people, here are the people of Penn Township, Westmoreland County, why the board chose to disagree with Dr. Tso, number one, and number two, to do so not only for the residents, but for the purposes of review by common pleas, then Commonwealth, then us, so that there'd be a better understanding of why the board did what it did.
you know, if you read these findings in both these cases and conclusions in toto, I think they're a statement unto themselves about inadequacy of the evidence Protect PT produced to sustain their burden. So I think these findings clearly established that the wealth of information that supported this decision came from Olympus's witnesses, and there was a lacking of supportive evidence for the opponent's burden in this case. So I think to compel more detailed explanations into this, I suppose in hindsight, it could be helpful, but our position is, you know, what's fascinated me about this case is these are the 9th or 10th or 11th proceedings before this board on unconventional natural gas operations. Protect PT was a participant in all but the very first one or two. They called experts in other cases. The Protect Council would have to acknowledge that the format and structure of these findings is no different to Dianus and Metis than it was in all the prior decisions that granted exception requests. And I'm not sure what's different this time from the analysis the board did in all those prior situations.
Councilor Justice Donahue, I think you just made understanding the basis for the decision. For example, the information that you just provided to us in your lead into your argument about the testimony that was put before the board regarding the lack of certain testing and certain investigation being done. That would be a fine reason for the board to state the evidence was insufficient. And we flipped, and I mean it's what the Commonwealth Court has been doing for years, and trial courts have been doing for years. Instead of requiring the board to set forth the evidence supporting its findings, The reviewing courts are put to the task of searching through the records to determine what the potential basis for those findings were. And let me just give you one example of this, and maybe you could explain this to me. Judge Wojcik, in writing the opinion in this case, referred to your opposing counsel's client's evidence as speculative. There is no finding by the hearing board that this evidence was speculative. Was Judge Wojcik correct that the evidence was speculative? See, he's making a finding that was not made by the hearing board. So what is the problem with the hearing board actually making specific findings of fact and conclusions of law that draw from it? What is the impediment to a board doing that?
I see your point, Justice Donahue, and I don't necessarily disagree with it. But our position is here that the findings and the conclusions that were covered in this case dealt with the issues of the lack of evidence produced by Protect PT. Again, in hindsight, would further specificity be warranted? Perhaps. I may have to concede that. But is the resolution of the case then that remand this to the board with findings consistent with this court's opinion that the findings aren't specific enough, and so the board gets more specific with its findings in the remand, and the decision's not going to change. So in this case, I'm not sure where that puts the parties. That's my position on it.
Mr. Sweeney, may I ask a question? It was raised by Justice Weck questioning the appellant. And that is there a difference between federal and Pennsylvania jurisprudence in the area of review of an administrative agency determination? And I make that point as follows. It's essentially the same as I understand it under the Federal Administrative Procedures Act. It's very narrow, and they review for arbitrariness and capriciousness, but the Supreme Court may have U.S. Supreme Court may have put a little overlay on that not too long ago when they say that reviewing courts must assess whether agencies examined the relevant data and articulated a satisfactory explanation for their decisions. That's a 2019 case. And I think they might call that the reasoned explanation requirement of administrative law. It's in the same case, and they say that's meant to ensure that agencies offer genuine justifications for important decisions, reasons that could be scrutinized by courts in the interest of the public. And as I kind of understood this case, it was at base whether the current standard articulated by this court is indeed sufficient or whether it should be enhanced in some fashion.
With apologies, Justice S.K.L.R, I don't do any federal practice, and I didn't assess federal law in regards to this, although my review of a breadth of state jurisprudence, I would think the federal administrative appeals procedures wouldn't be necessarily different from ours, although I think historically Pennsylvania law tends to be a little tighter than federal law is.
Yeah, well, that's fine. I appreciate that. But the case I'm referencing was Department of Commerce versus New York, 2019 case.
Yeah, and I'm not familiar with that. I think to answer the tail end of your question, if I might, I have a concern if this court begins to expand the standard of reviews here from error of law, abuse of discretion. You have a capricious disregard standard that's available in cases when an agency or a board or another fact-finding entity commits that type of conduct. And I think if you begin to open the avenues for reviewing courts to start doing what might become de novo assessments without a de novo.
I'm sorry, I was talking about the reasons that must be supplied by an administrative agency in support of its decision.
Yes, and I think the administrative agency is required to supply those reasons and those decisions, and these two decisions satisfy that requirement. I mean, it's not a numbers thing whether there's 10 findings and conclusions or 200 findings and conclusions. The issue is, have they explained the basis for their decision, and is that explanation supported by the record?
Thank you.
Thank you.
Counsel, what we have in this record along these same lines is one conclusion of law dealing with your opposing counsel's client's evidence. It was insufficient and not credible, period. And as you indicated, the local, and I think Justice Taylor's point is, does that need to be something more than saying not sufficient, not credible?
Each of these, Justice Donahue, each of these decisions was supported with in excess of 130, 140 findings and conclusions. The last 5 or 6 of those conclusions dealt with the 2 questions the board has to handle here. Did the applicant meet the requirements of the ordinance? And if so, did the objectors meet their requirement to show that there was something unusual or unique about this case that created this high probability of detrimental impact? The first 4 or 5 of those conclusions with regard to the applicant are very succinct and very direct. They met requirement A, they met requirement B, they met requirement D. The conclusion for the objectors is no different in character than that. The objectors did not satisfy their burden. And these conclusions are the ones the decisions are based upon and are supported by the preceding findings and conclusions. So in a perfect world, more explanation would have been better for there be a half dozen or a dozen more findings. Perhaps that's a lesson I take from this. But my position still is that these decisions are supported by substantial evidence of record, and the proper standard to review here is not capricious disregard. It's abuse of discretion and error of law.
Isn't capricious disregard a part of the test for in accordance with the law?
I don't disagree with that, but I don't think we reached the threshold issue of capricious disregard here, because I think even if you would open review of these cases to more scrutiny by an appellate or review court, that they could go in and delve into the facts and make their own decisions here, which is the flavor I get that the appellate wants. In these 2 cases, I strongly believe these decisions are no different.
I'm sorry, I was muted. Mr. Lucas?
Thank you, Mr. Chief Justice. Blaine Lucas on behalf of Olympus Energy. I'd like to focus just on a couple side issues that I think color the board's determination here. First, you have to keep in mind the township here over a 6-year period with lots of public input, including, I believe, from Protect PT, developed and adopted an ordinance that Mr. Chief Justice alluded to, is very restrictive. Less than 10% of the township's land mass is available. Protect PT actually unsuccessfully challenged that substantive validity challenge, in a substantive validity challenge that went up through Commonwealth Court, and this court did not take the case, arguing that it wasn't strict enough. Based on that ordinance, Olympus carefully selected a site that met the strict geographic requirements of the ordinance, and in the public hearing established it met all the other specific requirements of the ordinance. Then this is the critical point. At that point, the burden shifted to Protect PT to present evidence, not that there's
their impacts from oil and gas, or that Olympus's wells would have impacts, but that they would have impacts and have adverse impacts beyond those normally associated with that use. That's a long-established principle of Pennsylvania land use law. The Protect PT's lay and purported expert testimony was speculative and basically boiled down to oil and gas development is bad. But I think it's critical in terms of this abnormal impact requirement that Dr. S.K.L.R actually admitted that the impacts were similar. If you look at page 327 of the reproduced record, he stated any of these alleged impacts, normal or abnormal, Olympus agreed to multiple other conditions on the approval. Turning to the cumulative effects argument, it boils down basically to more is bad. They presented through Dr. S.K.L.R or anyone else, they didn't present any specific data as to anything. Air, water, specific air constituents, specific water constituents, specific locations, stages of development of an oil and gas well pad. In sharp contrast, Dr. Long testified extensively as to the actual air monitoring that had taken place in many points around Pennsylvania and other states where wells were clustered in close proximity to each other. And his conclusion was that there was no finding based on what that data was showing, whether it be for particulates or nitrogen dioxide or VOCs. There was nothing to suggest that the levels there were any different than you would find in a normal situation that would have any adverse impact on the health. And I think it's significant here, going back to the validity challenge that was made by Protect PT. Dr. Long testified before the Common Pleas Court on a lot of those same issues, and the court found his testimony to be credible, and he actually adopted their opinions. A couple things to also keep in mind with respect to this cumulative impact argument is pads, and the evidence was clear on this, these pads are not developed at the same time. And admittedly, the impacts of oil and gas development are more on the front end when you're drilling and hydraulic fracturing. The testimony was they wouldn't be developed at the same time, nor would they use the same truck routes. I think critically, though, most of the life of a well pad is when it's in permanent production. And it is a passive site, and there's kind of a misconception in the world that the drilling activity and everything continues on forever. And just one example of that from the record, reproduced record 817, 818, testimony of Olympus's witnesses was that once the wells went into permanent production, the traffic to the site would be less than one pickup truck a day. I challenge, I've served in Mr. Sweeney's capacity as a solicitor. I challenged to find any development of any sort that would have that little of traffic impact. The last issue I'd like to address is kind of the ramifications of Dr. S.K.L.'s testimony. And Protect PT in their brief argues basically that if wells are located within 1 kilometer of a residence, the community will suffer detrimental health impacts, and therefore that was the basis that these should be denied. In fact, at one point, Dr. S.K.L.R suggested it should be a 3-kilometer limit. And at one point, he basically admits, and this is a reproduced record at page 380, that state and township setbacks are inadequate. That's the issue we have here, is this Protect PT and their experts don't like the policy legislative decisions that were made by Penn Township. And from my client's perspective, they are very strict. There is much area left. This is just an improper attempt to override the legislative decision that these bodies made. It's also a backdoor attempt to relitigate the validity challenge. And more critically, if you accepted Dr. S.K.L.'s testimony that you shouldn't have a well pad within a kilometer of a home, that clearly would preclude any development in Penn Township and probably anywhere in the Commonwealth. Right now, with a 600-foot setback, less than 10% of the land mass of the township's available for development. Kilometers 5.5 times that. And even for the math challenge, at least like yours truly, it's clear if you increase it 5.5-fold, there would not be a spot in the township that could be drilled. And this is really consistent with Dr. S.K.L.'s admitted goal that he wants to a moratorium or a ban on oil and gas development. We would just respectfully suggest that the specific facts of a special exception application are not the forum where that to take place. Thank you.
Questions for any? All right, Mr. Lutz, thank you very much. We'll accept the case for decision 12:30, and I think the last case will be somewhat lengthy. So let's take a 45-minute break and come back and finish. Is that satisfactory, sir?
How much time? I'm sorry.
What would you like? Half hour, 45 minutes?
Doesn't matter.
Let's take 45 minutes, so we'll still finish early in the afternoon. 45-minute break. We'll start again at about 1:15. Thank you.
Thank you.
The next argument is in the interest of S.K.L.R and L.M.J.R, appeal of K.H. Representing appellant is Mr. Randall G. Klimchak. Representing the Westmoreland Children's Bureau is Ms. Deborah M. Nicholson. Not arguing but available for questioning and representing S.K.L.R and L.M.J.R is Ms. Dorian Patonic.
This case pertains to a petition from an agency to involuntarily terminate the parental rights of a mom in accordance with 23 Pennsylvania Consolidated Statute, Section 2511. The mother had allegedly failed to complete one of several court order requirements after a period of excess of 12 months. Orphans Court denied the petition, finding that the agency had failed to prove by clear and convincing evidence that termination of mother's parental rights was in the children's best interest. The Superior Court reversed, finding the record belied the Orphans Court's findings and that the court had abused its discretion in denying the petition. We granted allowance of appeal to examine whether the Superior Court's rejection of the Orphans Court's findings under Section 2511 conflicts with our holding in RJT, and whether the Superior Court improperly substituted its own discretion for that of the Orphans Court in this matter. Mr. Klimchak, feel free to begin.
Thank you, Mr. Chief Justice. May it please the Honorable Court. I would start by focusing on the testimony of one of the agency's witnesses, Kelsey Otis. She was this visitation supervisor for Justice Works, which was the agency with which the CYS agency contracted for visitation of supervision of mother's visits. Ms. Otis's testimony, I think, somewhat favored mother. It certainly wasn't all in mother's favor. She did note some negative visit issues, but Ms. Otis testified that the children, when the visits begin, the children greet mother with a hug and a kiss. They seem to be excited to be at the visit. Mother cooks a meal for them and serves it at the kitchen table, and they all eat together. At some point, the children then go into the play area and start to play, and a handful of times, mother will get on the floor and engage with the children while they're playing. They may watch a movie together, and mother watches the movie with the children. The testimony also was that sometimes she'll be on her phone as well and isn't completely focused on the children. So I understand that that wasn't in mother's favor. But I believe that Ms. Otis's testimony, even though it was elicited by the CYS agency, actually did say a lot of positive things, which established a bond between mother and the child, or at least give grounds that the Honorable Trial Court's finding of a bond between mother and the children was not an abuse of discretion, was not manifest unreasonableness. And if you couple that with the testimony of mother, that, of course, it's going to be self-serving. It's going to be her, she's a party in the case, and she certainly is interested in the termination case. But she testified that the children, they really, they tell her they want to stay with her more. They want to be at home with her and their little sister, and they ask her why can't we do that? Now again, the agency's supervisor did not say that she saw that or heard that testimony or that coming from the children, but these are credibility issues, which I think the trial judge weighed and came out in favor of mother. And I think coupling those two things with the fact that the CYS caseworker, in her 15 months on the case, she only observed 2 visits between mother and the children. Now, of course, she visited the children other times and talked to them when mother, not during mother's visits. And she seemed to focus, the only really detrimental thing she said there was that mother, she did say the children flourish with the foster mother, but she didn't really say anything detrimental about mother other than that, some of the older reports say that mother yelled at the children, but Ms. Otis didn't say that mother yelled a lot at the children, that her discipline was more appropriate, and that she would ask the kids to share or to apologize to each other if they were fighting. But there was a lot of improvement with the yelling. So I think given that, I think to say that the trial court, that there was no justification or no support in the record for the finding of a bond, I think that's not accurate. I think that the Superior Court, that there was evidence of the bond, and then at that point, as the court is well aware under the case law, we have to look at whether severing that bond would be in the best interest of the children under There's a best interest standard, of course, under 2511A8 as well as under 2511B. And I think that's where the judge, the top court ended up with, he again noted some of those things that I said. The testimony was about the beginning of the visits, the meals, all that together. But the judge also noted that considering that totality of the circumstances and in the absence of a bonding assessment telling us otherwise, we find that there was really not enough information given to determine whether there'd be a detriment to separating the bond.
Mr. Klimchak.
There's not a bonding assessment requirement. There's case law that says you don't have to have an assessment in every case. And I've been in those cases where parents haven't visited kids for 3 years, we're at termination, and I'm still asking for a bonding assessment at the trial, but I know that's not a strong argument.
Mr. Klimchak, can you hear me? Chief Justice Baer. Is your client continuing to see these children?
She is, yes.
How often does she see these children?
Currently, it's 8 hours a visit, 1 day a week. And that's at the agency's discretion. My mother has asked for more than that, but that's what they're giving her now until this is resolved.
Well, it's also at the trial court discretion if you take it to the trial court.
That's true. Yeah, I agree. Yes, Your Honor.
How long have the children been in their current placement?
Since the case began, at the time of the termination trial, it was about 15 months old, and that was back in January of 2020. So I want to say that was in probably late 2018. So
was there family finding done in this case? You know what family finding is?
Family finding, yes. You mean certainly, yes.
Was family finding done in this case?
Family finding was done. The foster mother is the aunt of the mother in this case.
So this is a kinship care placement.
Kinship care placement, yes, Your Honor.
Is the foster mother the sister of the biological natural mother? You said she's
it's straight into the child, aunt to the mother. So it would be the sister of mother's father.
Counsel, this is Justice Doherty. I'd like to get to the issue granted. The question of concern is that you're arguing it was abuse of discretion from the trial superior court substituting its judgment, correct?
Yes, Your Honor.
Share with me, the child had been in placement over 15 out of 24 months, correct?
That is correct, Your Honor, yes.
And it's fair to say the Federal Adoption and Safe Families Act requires the state to file a petition to terminate parental rights if the child's been in 15 or more months, correct?
Yes, unless there are compelling reasons, but yes. Your Honor.
And this record is absent as to compelling reasons as why the trial court did not follow the federal mandate, correct? Or do you say where in the record?
That is correct, Your Honor.
So I guess the question on Federal Adoption and Safe Families Act.
Because the determination needs to be filed and pursued after the 18 months or after the 15 months. However, that still doesn't take away the best interest standard, where when you have the termination trial, you look at the best interest, and we still have to examine those bonding issues and the severing of the bond issues.
Okay, and my last question for you, there was concurrent planning on this case, correct?
There was, yes. And
okay.
Yes. And adoption was the secondary goal. Yes.
Fair enough. Thank you.
Thank you, Your Honor. Thank you, Judge and Justice.
All right. Any other questions from anyone? Very well. We'll proceed. Our next advocate is Ms. Nicholson. Hold on. We're bringing her up.
I believe I'm unmuted now.
You are.
Thank you, Chief Justice Baer and Justices, and may it please the court, my name is Deborah Nicholson, and I'm here on behalf of the Westmoreland County Children's Bureau, and it's the position of the agency that the Superior Court did not substitute its judgment for that of the trial court, nor did it reject the trial court findings. There are a number of errors of law in the trial court opinion, The first one, the trial court said that the analysis for section 2511A8 is the same analysis for that of 2511A5, which is incorrect. 2511A5 focuses on, well, it doesn't focus, but it also considers what happens should the parent be given more time and are there services available that would help the parent. The trial court added another prong to section 2511A8, which made it a 2511A5, adding into, if we give mother more time, she may be able to alleviate the circumstances that led to her children being in placement. And there is no such prong on 2511A8. The trial court also erred when it said that under 2511A8, that it may grant termination under 2511A8, but the law says may grant termination and not shall grant termination. And the trial court said that we therefore then have the discretion to grant termination or not grant termination. The trial court also erred in under section 2511B that any efforts made by the mother after she was served with the termination petition should be considered, as the trial court was urging here. Also, the trial court incorrectly considered that mother was raising another child. And as for bond, the trial court did not consider the intangibles that the foster mother provided to the children, such as love, support, security, and comfort. And just stated that the agency made a blanket statement that the children were flourishing, but ignored the testimony that was actually given by the agency caseworker. The record also...
Counsel, this is Justice Doherty. Your comment there that the judge, your comment was that the judge did not give its appropriate weight to the evidence, correct?
That's not exactly my comment. The trial court stated that the caseworker just made a blanket statement saying that children are flourishing when the caseworker expanded that the children are doing more than flourishing. They look to the foster mother for guidance. They look to her for love. They see her as mother. The foster mother meets their needs. But the trial court just said that the case...
Weighty, correct?
I wouldn't say that it was a credibility determination. I do not believe that the trial court considered the testimony of the agency, and I don't think it did a proper analysis. It just said that the agency statement was that the children were flourishing.
Okay, so other than that, when you say that trial court did not consider the testimony, where in the record are you gleaning that position?
I'm gleaning that from the trial court opinion when the trial judge just said that the agency made a blanket statement saying the children are flourishing.
Okay.
And that was in the trial court's first opinion. The trial court had actually submitted two opinions.
And it's fair to say the record also includes of a strong bond between mother and children, correct?
That's what the trial court characterizes it as, but there's really no testimony that it is a strong bond. The children...
I apologize. So it appears that you're challenging the court's credibility in its findings, not an error of law. What is the error of law with regard to 2511B? What was the error of law?
The error of law with 2511B, the court just looked at what it considered to be a bond. It didn't consider the intangibles that the foster mother was providing, and that under the law must be considered also.
And can you share, I just apologies. Under 2511B, can you share with me where those other intangibles are? It's the rights of a parent shall not be terminated. We know that. We're primary consideration to the developmental, physical, and emotional needs of the welfare of the child.
That comes from case law, Your Honor, and I don't have the site immediately in front of me.
Okay,
but I'm sorry, go ahead.
I was just going to say, there's also contrary case law that says it's dealing with the developmental, physical, emotional needs of the child with the biological parent, correct? That's why we have bonding evaluations.
The law does not require a bonding evaluation. The caseworker is more than capable of speaking to bond. This visitation supervisor was not qualified as a bonding expert and could not address bond.
In your career as an attorney in the child welfare realm, have you ever seen a bonding evaluation with regard to the children and the foster parent? Or has it always been a child and a natural parent?
Historically, when the agency does a bonding assessment, we do the bonding assessment with both the foster parent and the children and the foster parent and the biological parent.
Thank you.
However, this is Chief Justice Behr. It's mom who has a constitutional right, fundamental constitutional right to raise her kids. The foster parent has no rights whatsoever. She's intended to be a surrogate to the extent that mom cannot fulfill her duties. You don't fight with that, do you?
I do not.
Okay. The agency here, the trial court participated, gave mom a laundry list of things to do that, frankly, I think I would have a hard time achieving. Continue mental health treatment, participate in nurturing parent instruction, participate in anger management counseling, obtain appropriate and stable housing, secure and maintain verifiable and livable sources of income. That's laundry list dependence. That's not what we need to have these children live with their mom. It's sort of let's cure every ill. And to my credit, the witness that you just recommended to us, Ms. Hendershot, said she successfully completed nurture care. She successfully completed anger management. She had stable health with her mother and grandmother, and without the second husband who arguably was abusing the children. And she was working full time. About the only thing she didn't do is finish her mental health counseling, and that's because she said she was going to lose her job. Now, how do you fault her? And how do you, maybe a better question is, how do you default her constitutional right to raise her kids, which is what the trial court found here, at least on an interim basis, under that kind of record. I think she's done a yeoman job.
Your Honor, if I may, the anger management that she completed also recommended that she continue with her mental health treatment and with her medication management. That she did not do. And as for the housing, mother also stated that she was looking for housing because the housing that she had was certainly not adequate to bring in 2 more children. And if you look at the circumstances that why the children were brought into the agency to begin with, there was a third child, which she actually did put up for adoption. The other 2, the children in this case, she signed the consent and then later revoked it because she thought she wasn't going to see the children. But the third child that she did go through with the adoption, that child was suspected to be a shaken baby syndrome, although unfortunately it couldn't be proven because that child came into agency custody so late after the incident had happened. So there's plenty of evidence that mother needed mental health. Mental health was in every review order. Mother never challenged that. And mother just said that she was too busy to get mental health. Well, if she's too busy to get mental health, then she really doesn't have the time to be parenting 2 more children.
In fairness to her, she was arguably too busy. I'm not excusing her, because of the mandates you put on her that were overwhelming.
The mandates were not overwhelming, Your Honor. The mandates met the needs of what she needed to do to safely parent these children. We also had to consider the safety of the children. Mother had definite anger issues, and even the visitation supervisor said, although she wasn't yelling at the children a lot, she was still yelling at the children.
Although when the trial court's finding in the case was not that mom would not, fortunately, be terminated in due course. It was that the agency's move was premature because of the amount of progress mom had made. Well, why isn't that the trial court, and it seems as we've said this repeatedly today, who saw the witnesses, listened to the credibility, has followed mom, and there's a law on this, as you well know, has followed mom from the very beginning, has followed Ms. Henderson and the other agency witnesses from the very beginning. Why isn't he within his discretion and not abusing the law by saying, I'm not terminating today. She's doing better. She may be able to parent her kids. Let's see what happens.
Your Honor, under 2511A8, there's no wait and see what happens. That's a 2511A5. And that's where the judge made a mistake, an error of law, stating that we can give her more time under 2511A8. That's where the trial court made a mistake, saying that if the conditions are met, I don't have to terminate. I have that discretion.
I think that's an outrageous argument. I have voluntary grounds. You can't show me a case in the Western Hemisphere that says a trial court doesn't have the discretion to turn down a termination under all the facts and circumstances. If you do, it's unconstitutional when it gets discussed.
Or where I think the problem lies with the trial court says even if the evidence is clear and convincing, I don't have to terminate. And that's where the error is. Not that the trial court can't listen to the facts and make a determination. And if the court finds that the conditions for termination were not met, then the court certainly can refuse to not terminate.
So you're saying that when I go back and read with a fine-tooth comb, the trial court's going to say, yes, all the conditions for termination are met, the actual grounds for termination as well as the best interest, and notwithstanding, I refuse. I'd be surprised if the trial court said that. But
the trial court.
I'll look at it for you.
Okay.
All right. Thank you.
Counsel, it's Justice Donahue. Assume for the sake of argument, and I happen to agree with Justice Baer, but let's assume for the sake of argument that you're right, that the trial court had to find grounds for termination under A8. How does that get you over the hump that he concluded that there was a beneficial bond existing between the mother and the children, and that was worth saving?
Well, there's no testimony that the bond was beneficial. In fact, mother has been visiting these children inconsistently throughout the life of this case, and there was a period of time that she signed to give her rights away.
But the trial court was free to reject all or part of the position that the agency was taking. You seem to be making the argument, as does your brief, that the trial court must accept the evidence that you put forward. And correct me if I'm wrong, that is clearly not the law. The trial court judge can weigh the evidence and make a determination based upon that weighing of the evidence.
And I understand your argument, and I agree with you. However, the trial court did not consider the evidence of the agency and said the agency just made a blanket statement that the children are flourishing, and that's not the case. And the trial court did not look at the intangibles that the foster mother provides.
Counsel, as questions are not coming, I just have a couple more as I try to scan my notes. The Superior Court in Aplt has said the ability to care for children of other children is irrelevant in these proceedings. It strikes me that that's a errant ruling, that could go to the weight, but that her ability to care for other children certainly seems relevant when we're assessing her ability to care for these kids. Do you agree with ALD or disagree with it?
I have mixed emotions about it, but where I would distinguish ALD from this case is that when mother had 3 children, she was not able to care for 3 children. We have her stating now that she has 1 child and she has to work, so she doesn't even have time to do her mental health treatment. So I think you have to look on the ability to care for more than 1 child too.
Counsel, Justice Doherty, I know you keep making this statement that the trial judge, a blanket statement, quote unquote. The question I have for you, and correct me if I'm wrong, did not the record reflect that the justice work employees who testified that over the course of child being in foster care over 2 years, that they only observed the interaction maybe 1 or 3 times at the max?
Well, unfortunately, we had a turnover in supervisors.
That's not the question I asked, counsel. When you said the judge made a blanketed statement that there was a general statement, I'm asking you, the record reflects over a period of 2 years, the agency's witness testified as to their observation only on, at a maximum, 3 supervised visits. Is that a yes or no answer?
Justice Works, yes.
Thank you.
However, if I may add, though, there is a period of time where mother had wanted to walk away from the children, and thus the caseworker wasn't viewing the visits, and the caseworker sees the children in their foster home monthly.
And the judge took that into consideration and gave it what the court believed to be the appropriate weight of that testimony. Yes or no?
I would disagree with that.
Counsel, again, Chief Justice Barrett, I think my last question is I continue to rifle through those. I wrote on behalf of the court, obviously, RJT, which said that appellate courts are not appropriate to make the very close calls in a goal change proceeding on fact-specific determinations. And there's some discussion in this case that should not be extended to these facts. It seems to me that it should be extended to this entire genre of cases because they have the same considerations, which is the intense factual gradients and close calls, which trial courts make, not on a cold record, but seeing and listening to everybody and knowing the case over a period of years. Do you have any feeling on whether RJT should just be extended to cases within a dependency forum, or should be confined to goal changes only?
I think the finding in RJT is probably consistent with the other mandates that we've had from the court, such as abuse of discretion and finding of fact. The only thing that wouldn't apply, this, as you had stated, this is a goal change case as opposed to a termination.
Does that make any difference? As a matter of applicability of this law to those two different types of dependency matters.
I think where I don't see the ruling in RJT was a limited ruling. The Superior Court had erroneously held that because the child was in custody for 15 or 22 months and that there was no reunification that was imminent, that there had to be a termination of a parental rights petition filed in a goal change. This is not a goal change case. This is a termination. I think where we disagree is that I believe that my argument is that there was an abuse of discretion here.
All right, so I take it that RJT, in your estimation, would apply here, could be extended here without doing violence to the law. And your position is that you prevail in any event because the Superior Court did not abuse its appellate standing standards in reversing this trial court.
I believe that's accurate, Your Honor.
Okay, thank you. Do we have questions from any other justice about anything? All right. Ms. Potomac, I know you're the child advocate. You were not intending to argue. Do you want to say anything?
No, Your Honor, I don't have any argument to make.
Hearing nothing further, we will take this case under advisement, and we thank you all, and that will conclude our spring argument session. And justices will get back together in about 5 minutes.